Good afternoon, all. This hearing is in the matter of CFI 073-2024 and is being held by way of video conferencing before His Excellency Justice Andrew Moran, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by R.W.K. Goodman, L.l.c. The lead counsel is Mr. Tom Montague Smith, KC. The defendant is represented by Altamini and Company, and lead counsel is Mr. Alex Potts, KC. Thank you, Your Honour.
Thank you very much, Lena. Well, good morning, everybody, wherever you may be, in the Middle East or in London. This hearing is listed for 2 days, just one or two matters before we begin. That listing was at a time when the parties may recall, due to various difficulties, I had not received skeleton arguments, and it seemed to me there was insufficient time for the hearing when it was previously listed. I've now had an opportunity to read everything that I've been asked to read, and a good deal more, I think, besides as well, following up references to authorities, a lot of which, of course, I'm very familiar with. So I'm hopeful that it may not take 2 days in the end, but it was necessary that I afforded you all that time to make sure that nobody was under any pressure, and you are not under any pressure to finish this hearing in any shorter time. You will take what time within the fixed period that you need to advance your submissions. I tell you that I've read everything, so you can take things as shortly or as focused on whatever points you wish to emphasize. I have a number of documents which I've extracted that I'm referring to, probably as you likely do, the contract, the amended particulars of claim. I'm using the amended particulars of claim, not by way of any prejudgment, but because it's all contained in that one document, the claim that is intended and it is sought to pursue by virtue of the claim itself and the amendment application. So I'll be looking at that, which begins at page 1629. That's the other problem. Somebody put the index at the front of the bundle, so we're all the references are 10 pages behind. I think you should have got a message from me. Either you can add 10 to your number when you give me a reference, or I will add 10. It doesn't matter. I'm capable of adding 10 to whatever figure you give me. So is there anything you gentlemen wish to raise by way of housekeeping? We have an application which I only recently became aware of, to admit further statements, an application of the 5th of December, which has been responded to. I saw those late last evening, but I've been able to read them. Have you reached any agreement in relation to that, or is that application to be pursued at the outset? Mr. Potts, I think.
Yes, thank you, my lord. Well, to answer that question, we haven't reached any agreement on it, so it's a live application which your lordship will have to determine. I don't have a very strong view as to whether you should determine that as a self-standing application at the outset, or whether you admit the material de bene esse at the outset and then resolve the question of its admissibility as part of any ruling at the end, having heard from both of us. That could often be the more efficient approach if time is limited, but if your lordship has more time than we all thought, then we could obviously rehearse all the arguments. There are a few other housekeeping points maybe I should just touch on at the outset.
Can we just deal with that one first of all, because my view, I'll say it immediately to Mr. Montague Smith, is that I wouldn't admit it de bene esse. Frankly, Mr. Potts, I'll tell you, it doesn't seem to me to make a great deal of difference what the position is. Mr. Mante is at the moment not guilty of any offence. That is the position. There are proceedings. The issue which you rely on of breach of confidence is there for you to rely on whether the criminal proceedings are concluded for or against Mr. Mante in due course. So I don't really think it makes a great deal of difference, but I'll be listen to you to be persuaded to the contrary as you wish. But for the moment, my inclination is simply to consider the statements as I have done de bene esse, and if necessary, I will make a ruling on the application with my rulings in general. Mr. Montague-Smith, what's your view?
Thank you, Your Honour. I mean, you read the material, so
yes.
You considered it de bene esse.
Yes.
I think our concern about it is, firstly, we don't understand why it's being introduced, other than for pure prejudice, because there was, in the application notice, a complaint that the information had been obtained in breach of confidence or in some unlawful way, but that was not pursued in the skeleton argument. And indeed, actually, in the evidence, and we'll come to this in due course, it's very clear that the information comes from the CRM system, the customer relationship management system. And it's very clear that the defendant gave not only Mr. Fontmante, but also the team access to that information voluntarily. And you can see that in emails and documents in the bundle, and it's admitted by Mr. Texera in his witness statement. And I can show you that if you like.
Well, not at this stage. We're getting into argument about it now.
Well, I don't want to do that, but no, sorry, didn't mean to cut across you. Yeah.
On the simple point that, as you say, I've read it because it's an application placed before me. I didn't see it until late in the day for reasons which are completely immaterial. But I did read it last night, wanting to be sure that I'd read everything necessary for this hearing. There was no message to me that I should not read it. So
no.
Which a party could obviously have placed before the registry. So I have read it. My inclination is to proceed, having received it and read it de bene esse, and I will deal with it even so far as I consider it to be necessary at the end of the hearing.
Understood. Thank you.
Very well. So, Mr. Potts, your other housekeeping matters that you wanted to raise.
Well, I mean, it may be at risk of repeating things your lordship's already observed, but just so I'm entirely clear, what your lordship should have is a primary hearing bundle, which is, I regret to say, a very long bundle. And as you pointed out, it had inserted into it an index of 10 pages, which pushes the numbering off by 10 pages. Yes. What for some reason doesn't seem to be working for me, and I don't know if it's true of all representatives in the court, is that normally there's the electronic platform, the bundle sharing platform that the court has,
yes,
where one can link through to it. But I don't currently have access to that, and it may just be a function of the way in which the bundle was uploaded some months ago, and perhaps the link's not been refreshed. But I'm just working from a static PDF of that bundle.
As am I, Mr. Potts.
Okay. So I'm not sure if I'm the one to apologise for the state of affairs, but perhaps if Mr. Montague-Smith can confirm he's also working from a static PDF. So we will have that.
Yes. So sorry, I was asked to confirm it. I confirm it. I think that, as I understand it, the difficulty is at the DIFC court's end. It's obviously the defendant's team who've uploaded and are responsible for the bundle, but they have not been able to get the existing bundle onto the platform in a way that's accessible for all the parties. I understand it's a technical problem in the DIFC court.
Right.
But we're all suffering from the same problem.
Well, is there any reason I want to be absolutely satisfied that there's no reason why we shouldn't proceed, that other parties who are entitled to have access to these proceedings and the bundle should have, as we have, either a static PDF or access to the bundle on the platform? I want to be sure. I don't want any complaints subsequently that they were not able to participate properly in the hearing. Can you confirm, both of you, that all involved on both your sides have access to the necessary materials to do whatever their job is in the conduct of this hearing?
Yes, there's no difficulties from my side, certainly.
Right. Thank you.
Yes. I mean, if I can just check, my bundle is 3,663 pages. So I
Yes.
assume yes, in which case, from my side, we've got everything we need.
And the supplemental bundle is 204 pages.
Perfect. Yeah, yes,
Yes.
that's correct. The only reason I mention it actually for your lordship is because some judges prefer to use that platform rather than a standard PDF, and so I wanted to make sure you weren't inconvenienced yourself. So buried within that, of course, are our respective skeleton arguments, which
Yes.
hopefully you have been able to identify or have separately, perhaps.
I have them separately again for your assistance.
The reason I just wanted to mention those at the outset is because obviously they're both quite comprehensive.
Yes.
And no doubt that horrified your lordship when you first received them, when you did, and resulted in the adjournment and the revised time estimate. But from my point of view, I would maintain and still have maintained that actually this could be dealt with in a day, although with Mr. Montague-Smith, we've not had a chance to discuss specific timing or guillotines for oral submissions, which in turn comes me on to asking your lordship whether you had in mind any particular times today that you would wish to break.
Yes, that's a very good question, because obviously there are parties in Dubai, personnel in Dubai, if I can put it that way, who will need their lunch. I normally run for an hour and a half with a 12 o'clock start, or 2 hours for an 11 o'clock start in Dubai. Can I confirm that a 1:30 Dubai break for lunch of whatever is required? Most people say 45 minutes is plenty to get a sandwich and a cup of coffee and proceed. But if you want longer, I will give parties longer. And we can get cracking on that basis. I will adjourn at what will be 9:30 UK time, and then we'll resume at would be 10:15, 10:30 UK time, and the corresponding 4 hours on in Dubai. What would be your position on that, Mr. Potts, first of all?
That's fine by me, but then at the end of the day, again, apologies for my own ignorance here, but what time would we then sit until?
Well, if it appears that we're going to finish this case not under pressure, I stress again, within the day, and nobody is struggling in Dubai where they're later than we are in the UK, then we will continue to finish it. But if it's clear at the end of your submissions that we're not going to finish it in the day, and I should hear Mr. Montague-Smith in whole tomorrow, I will do that in one piece. So does that give you sufficient guidance as to how we might proceed?
Yes, and again, sorry for being obtuse, but does that mean effectively 2 p.m. UK time that we would draw things to an end to accommodate Dubai, or would your lordship be planning to sit a lot later than that? Or
no, I think at 6 p.m. in Dubai is late enough for everybody. And if anybody protests, I can't see people protesting, obviously, in Dubai. Then please let me know. You'll no doubt have a means of communication. The ubiquitous WhatsApp, or BOTIM, as we use in the Middle East.
That's very helpful. Thank you. The other point, it's not with a view to rehashing the question of the supplemental materials that were put in and the subject of application for permission, but in a sense, we do actually endorse your lordship's view that the subject matter of the criminal proceedings and the status of them are largely irrelevant to what your lordship has to decide on these applications. But the reason that they're there is actually a consequence of what was put in the claimant's evidence and skeleton argument back in June. And because it seemed to us that both Mr. Montague-Smith in his submissions and Mr. Fontmantier in his evidence were seeking to derive some forensic advantage from what they said was a complete acquittal and a complete termination of the Dubai criminal proceedings, your lordship, now that we are here today in December, does need to be appraised of the true factual position as we sit here today. And because your lordship had directed essentially that neither party should file further evidence or update their respective skeleton arguments, it is, we respect suggest necessary for your lordship to know that those passages in the evidence and in the skeleton arguments cannot sensibly be relied upon.
Sorry. Can I just say, what we wrote in our skeleton argument was true when it was written, and there's been a subsequent appeal.
Yeah.
So we accept that.
Can we move on from this, gentlemen?
Yeah.
The position was well explained in the responsive statement from Mr. Dodman, is it? I hope I've got his name correct. And I've already given a provisional indication that I don't regard the criminal proceedings as really of any relevance to the issues which are before me. I have heard both parties' positions on it. I will consider it if either of you submit that it is relevant and can persuade me it is relevant. At the moment, it seems to me that the point about breach of confidentiality stands alone, distinct from the criminal proceedings. Whether there's any substance in it or not is another matter, which I will consider. So I'm minded to leave it at that and let us get on with the submissions, unless there's anything else you wish to put before me at this stage.
No, I apologise. I wasn't trying to antagonise your lordship, of course.
No, I'm not antagonised. I don't antagonise easily.
But the reason I mention that point is just essentially to illustrate the fact that there's been this passage of time between June and today's date. It's also relevant to note that, with respect to the next housekeeping point, essentially, but I'm sure you detected this from the submissions, can I ask you to look at the strikeout application notice, which you'll find in the main electronic bundle starting at page 87. Sorry, page 77, using the pagination.
Yes. Yes, you've added 10. Thank you.
So when you read the detailed text of the grounds in support of the application, bearing in mind that there's an application to strike out and an application for immediate judgment, one of the grounds, which is buried in paragraph 2 under the words because, is the subparagraph 2.2, where it was submitted that the claim is an abuse of process in circumstances where at the time the application was made, the claimant had no license to trade and appeared to be trading without proper authorization.
I'm sorry, I'm reading it.
Sorry, so
you're not directing it.
Does your lordship have the application notice?
I have the application notice. Are you on page 78?
Sorry, page 78.
Yes, and paragraph 2.
Yeah, the paragraph.
Main paragraph 2.
Main paragraph 2 starts. The claim is an abuse of process.
Yes. And 2 is the claimant has no license to trade. This is subparagraph 2, and therefore appears to be trading without proper authorization.
Yes, and so I just want to flag up. We'll get into each of the grounds of the application in further detail, but I want to flag up at the outset, essentially, so there's no confusion on this. That was correct at the time the application supporting evidence was filed.
Yes.
It seems that the claimant subsequently renewed or restored its license and then addressed that in its responsive evidence. So for today's purpose, that particular ground of the application is not pursued as a matter of substance, although yes, it may be relevant on the question of costs in due course. And before we then get into the meat of the application, of course, to state the obvious, the other application before your lordship is the application for permission to amend.
Yes.
And so the way I propose to deal with that, rather than having a series of sequential applications dealt with separately, is that I try and address that as part of my submissions on the application to strike out and for immediate judgment, recognizing that permission has not been granted and my learned friend would need to apply for and secure permission to amend. the reason that's, I suppose, important, but to state the obvious, is that whereas we may bear the burden on the strikeout application to explain why the case is an abusive process or discloses no reasonable grounds, the court, I would invite it not to overlook the fact that when applying for permission to amend, it's the applicant seeking permission to amend that has to be able to demonstrate to the court's satisfaction, that the proposed amendments disclose real prospects of success or reasonable grounds, and that they are properly particularized.
Yes. Very well. I'm conscious of that, and I expected you to deal with both applications in one set of submissions. So I've approached the matter on that basis.
But I certainly wouldn't want this hearing to start from the premise that you should approach it on the basis that those amendments are either agreed in principle or approved or essentially going to be granted in any event. But because we do, as you will have seen from our skeleton, take issue with the drafting of those amendments.
Yes, I've seen that.
Now, with all that introduction having been said, can I move on then essentially to the substance of my submissions in support of the application?
Yes.
I'm not going to try and repeat or recite every point we've made in our evidence or in our written skeleton argument.
Thank you.
Your Lordship has very kindly indicated you've read it, and we would endorse and maintain everything we have said, subject to the qualification I've made about the license point. What I'd like to try and approach matters on the following lines are these. I'd like to spend a bit of time actually showing you what we suggest are the core and key documents in terms of both the pleadings, but also, for example, the agreement, that is the fons et origo of this dispute, as well as the amendment. And then some of the matters that resulted in the litigation before Mr. Justice French, which then was followed by the termination notice that my client gave. So we'll need to look at that termination notice as well. Before we then get into the submissions on the law and the application of the law to the circumstances of this case, when I approach my submissions, what I'd like to do is actually reverse the order of events from the application notice and my draft skeleton and my skeleton. So try and engage with the question of the merits, the reasonable prospects of success, or the real grounds, real prospects area, and then come back to the abusive process points. Whereas logically, the application is premised on the abusive process points being addressed first, and then the reasonable grounds points being dealt with second. And I hope that by approaching matters in that way, when we come to conclude, I'll have been able to illustrate, by reference to enough material, why it is we say that this case is both hopeless in whole or at least in substantial part, but also abusive and vexatious. And if that approach is, in a sense, acceptable, subject to any questions your Lordship may have at any point in time, that's what I'd hope to cover. The starting point for all of this, of course, is the claim form, and it does, I know your Lordship's looked at it already, but it's worth just revisiting what the claim form seeks in these proceedings. And so if I can ask you to look, please, at page 24. It's the red paragraph numbering is 14 at the top right-hand corner, but I think it's...
Yes.
Sorry, so the claim form starts at page 11, and we get through to the text of it, in which there's a summary of the claim. And the remedies being sought in these proceedings, I mean, it's just worth looking at the figures being sought because they are eye-wateringly large. The first one is a claim for 54 million dirham, either in debt or in damages for allegedly unpaid fees. The second claim is damages sought for non-payment of fees. Apparently, those damages are sought on the theory that there will be some 6% compounding annually. Alternatively, that would be characterized as some form of interest claim. 3, a damages claim for wrongful termination, presently estimated at 81 million dirham. And then a claim for an alleged award under Article 42 in the sum of 270 million dirham, with then another claim for interest, such further or other relief as the court thinks fit, and costs. So where that gets you to is, in summary, in total, but in a sense, this could be the floor rather than the ceiling if the claim were to evolve from the claimant's point of view, is a total claim amount of 405 million dirham or 110 million US dollars, plus costs, plus interest, and so forth. Now, that is a staggeringly large amount of money. And if one is just simply to think about the case management of a case which starts demanding that much money, one can automatically see that a defendant is bound to take that very seriously in terms of how it approaches the defense of that claim, as well as the applications that might need to be made on the way to its resolution. But also, one could expect a claimant to be somewhat rigorous in the approach that they take to pleading and evidencing and substantiating that sort of claim, rather than approaching matters in a rather rushed or cavalier fashion. And we would say that whereas the court might take one view if the claim is worth $50,000 or $2 million to complaints of abuse of process, the court should already be alive to the possibility that the claim has been deliberately exaggerated for collateral purposes. Now, that may be with a view to provoking settlement, or as in this case, with a view to attracting the attention of third-party litigation funders. And you will have seen in the evidence that this is a case where the claimant, being very coy about the state of its own finances, has sought to obtain the support of litigation funders, and that's resulted in the skirmish that is still pending before the Court of Appeal about security for the defendant's costs. So that's really just simply the claim value and our invitation to the court to treat the case with a particular degree of analytical rigor and caution before simply assuming that allegations of fraud claiming $110 million should just be allowed to move forwards to trial without careful scrutiny. Now, your Lordship has mentioned you're working from the amended draft at 1629. So yes, perhaps we can just take a moment to jump forwards to that, please.
Yes, I have it in front of me, printed off.
So I'm sure your Lordship has read all this, and so I don't want to recite every paragraph. But the claim, as presented, is stark in its summary of what it says are the relevant applicable contract terms, to then its assertion, which is the one which you see in paragraph 7.1.
Yes.
So at page 1634. Having set out what it says are the relevant express terms in the agreement and then the amendment, and then having said at paragraph 7 that the claimant relies on the express terms for their effect, it then starkly asserts at paragraph 7.1 that the reference to the word seller in the definition provisions, definition of gross revenue, and we'll come back and look at the contract in further detail, is a manifest typographical mutual mistake, and the parties intended this should be a reference to the buyer. Now, there's then various arguments identified as to why that's the case. But just pausing there, this is a fundamental and crucial element to the claimant's claim, in a number of different ways. One is the assertion that you reinterpret or correct the actual express terms to say something completely different to those which they do in fact say. But that once you've done that process, allegedly with retrospective effect, you should then, the court should then jump to the conclusion that my client has not only acted in breach of an express term that is meant to be interpreted in a way which it simply does not read in express words, but not only has the breach allegedly occurred, but the breach has been deliberate, dishonest, fraudulent, allegedly, and on their case, in order to trigger the claim for supposed aggravated damages under Article 42, that not only was it deliberate and knowingly deliberate, that it was particularly egregious or offensive. Now, I'll come on in due course to the arguments about Article 42 and the circumstance in which exemplary damages or aggravated damages are available or might be appropriate. But just by way of introduction, if you ask yourself, is it realistic to think that a reputable real estate agency business such as Sotheby's International Realty, is it realistic to think that they or their principals knowingly and deliberately acted in breach of a contract in such a way that one can suggest it's egregious or offensive or offends the morality of the court, in circumstances where, at the very least, there must be a reasonable argument as to what this contract means, given its express words and the claimant's own case, that the court has to approach it on the basis that the word seller means buyer or black means white. The very fact that the definition of gross revenue talks about the seller's gross revenue immediately extinguishes, in my respectful submission, any possible argument that there's been a deliberate breach of contract on the part of the defendant. It's not even arguable, because on the claimant's own case, the contract doesn't even say what the claimant alleges the contract means. Now, at the outset, the claimant refused to countenance the proposition that the logic of the claimant's case necessarily requires an application to the court for rectification of the agreement. Because what the claimant's real case is, and one could say it's a case of seller's remorse, but what the claimant's real case is, it appears to be, that although the claimant had charge for the drafting of the agreement and drafted it in the manner in which he did and circulated it for review, approval, and execution, there was a mistake made in the wording of the contract, which the court needs to rectify. Now, I'll come on again to why that the amended pleading, which you'll see has been rather casually inserted at page 1636, paragraph 7.1.6. I'll come on a bit later as to why this doesn't actually address the difficulties of pleading out a rectification claim. But you'll see at 7.1.6 that the further alternative proposed amendment, that the definition of gross revenue should be rectified by deleting the word seller, substituting the word buyer, pursuant to Article 41B of the Law of Damages and Remedies, where, for the reasons set out above, L.l.c and SI had the common intention the definition should refer to buyer at the time of entry into the partnership agreement. By common mistake, the partnership agreement did not reflect such common intention. Now that we would respect suggest is the claimant's real case. It's not properly pleaded because it doesn't, for example, properly plead the alleged common intention. But when you ask yourself, how is it possible for a claimant to simultaneously seek rectification of an agreement so that the written contract as written is rectified pursuant to the court's effectively equitable jurisdiction. You rectify it with retrospective effect. How is it possible or plausible or realistic to suggest that a party can be accused of deliberately or dishonestly or cynically breaching a contract that has not yet been rectified by the court to say what the claimant says it should say? What any party properly advised should have done reasonably is, from the moment they identified the alleged fact that the contract did not say what they said it should, they would apply first to court for rectification if they had first followed the dispute resolution mechanism in the contract. And only once the court had clarified the true meaning and effect of the contract would they then go back to the counterparty to say, well, now that the contract has been rectified, and now this is the court's view of the true meaning of the contract, going forwards, please comply with the contract in the way in which we say you should. Now, but that point is important to have in mind as we go through the entire theme of the case, because just pausing there on the pleadings, can I invite you to just look now at the agreement? This does unfortunately appear a few different places in the bundle, but I think the first version of it was attached to the original particular claim.
I've printed it off again, Mr.
Okay.
And I've printed it, the version at page 37, red numbers at the top.
Perfect. Again, there's lots of this we'll have to come back to review in more detail. But can I ask you, first of all, to look at the dispute resolution clause, the mechanism for dispute resolution, which is at clause 19. So that's red page 53.
Yes.
Can you see it's headed Protocol to Solve Conflicts?
Yeah.
Now, I'm not going to sort of hazard a guess as to how parties approach conflict resolution in the Middle East versus the UK, for example. But you can see that in what was a long-term relational contract, it will be important for parties to approach the resolution of disputes or the solving of conflicts in a non-litigious fashion in the first instance. And this provides at clause 19.1, in case a dispute arises for any matter contained herein in this agreement, the aggrieved party should send a written notice to the defaulting party by giving it 14 days, to rectify / settle the issue. And then 19.2, if the dispute is not settled as per the above, then Mr. Damir Valiyev, a partner at AdCourt Dubai, will be appointed to act as a mediator to possibly settle a dispute within a maximum of another 14 days from the date of such mediation request by the aggrieved party. And then it was suggested in 19.3 that once the mediation process is reached its conclusion, the decision of the mediator will be final and binding. And if no resolution is reached, the aggrieved party can accordingly initiate legal actions as stipulated in clause 20 of this agreement below. And that's what then gets us into the governing law and jurisdiction clause, where you'll see that at 20.1, any dispute arising out of connection with the contract, including any question regarding its existence, validity, or termination, shall be subject to the exclusive jurisdiction of the courts of Dubai, and the contract shall be governed by and construed in accordance with the laws of the DIFC. The reason that's important is because L.l.c and Mr. Fontmante never raised a dispute. They never gave notice of a dispute relating to any alleged non-payment of fees. They never gave any notice of that dispute under the provisions of the contract. Had they said, we think you've underpaid us by reference to the interpretation of the contract, then SIR, Sotheby's, would have had the opportunity, first of all, to explain why the contract does not mean what they think it means, but also to raise the issue for resolution by a mediator if the parties could not within 14 days themselves negotiate a resolution of the issue. In this case, though, you may have seen there was a lot of attempts by Mr. Fontmante to renegotiate the agreement. One series of attempts at renegotiation resulted in the amendment to the agreement, but not satisfied with those amendments, efforts were then made to negotiate yet further, to renegotiate the terms of the agreement. And there were lots of moving parts to those negotiations because some of them related to the fees that he claimed he should get going forwards, but also there were issues to do with growth into other markets and the extent to which he or his company should participate as service providers in those other markets. And what then happened was that the defendant, quite properly and within its rights, decided that because it would be growing into other markets, it no longer made sense for it to be branded in the way it was, and it decided to rebrand. Now, we don't need to get into all the nitty-gritty of that, but Mr. Fontmante and L.l.c. applied to the court ex parte, in secret, without forewarning, without triggering the conflict protocol at all, seeking urgent injunctive relief, restraining the principal. This is an agent applying for injunctive relief against a principal from exercising its rights under the contract. And as part of that case, the injunction application, the pleadings, the evidence and support, very serious allegations of fraud and deliberate dishonesty and wrongdoing were made in unequivocal terms. Now, they were not properly particularized or properly evidenced, but they go from nothing, no notice of a grievance under 19.1, no opportunity being given to the principal to rectify or settle the issue within 14 days, no opportunity being given to invoke the mediation process with a view to forming an amicable resolution. But they start court proceedings essentially by throwing a grenade into the relationship. And the grenade throwing backfires because Mr. Fontmante and L.l.c's case is that so far as branding or rebranding is concerned, it's his way or the highway. There can be no possible argument to the effect that his interpretation of the contract is anything other than correct. And as it happens, not only did my client point out that his interpretation of the contract was wrong and self-serving, but the judge, Mr. Justice French, agreed with us. Mr. Justice French concluded in unequivocal terms that L.l.c's proposed interpretation of the contract did not even have realistic prospects of success. It did not even satisfy the serious issue to be tried threshold for the purpose of an injunction application, and he dismissed the claim. Now, a couple of points on that are particularly worth noting. If we can just now jump to Mr. Justice French's judgment, which you should find, I hope, in the bundle at page 144.
For some reason, I'm looking at it 3 Well, the parts I've highlighted 3206 onwards, but I've got
that's fine. I think maybe it's again one of these ones which is features twice.
which paragraph do you want me to look at?
Well, the first point I want to just draw to your attention is, can I ask you to look at paragraph 41, which is at page 3209? This actual section is the judge's recital of the defendant's evidence through Mr. Texera. And at paragraph 41, he records the fact that Mr. Texera referred to the agreement. He said that Mr. Mantegna was the main driver of the agreement, having sent the original proposal in February 2019. He referred to a memorandum of understanding in 14th of May 2020 and 2 addenda to the memorandum of understanding. He stated his belief, apparently upon advice, the agreement did not give rise to a general partnership within the meaning of the DIFC's general partnership law. That appears to be common ground. Now that sentence there is not actually the judge's summary of the evidence. That's the judge's own observation relating to the fact that before him, both on the evidence and on the submissions, it was common ground that despite the agreement's use of the word partnership in a colloquial sense, the agreement does not satisfy the requirements of DIFC law for a true general partnership. It's not a partnership. It's just the parties have used that word inaccurately, essentially. Now, that point is relevant in lots of different ways in this case, because it illustrates the many difficulties, for example, with Mr. Fontmante's assertions that my client somehow owed his company a fiduciary obligation. Quite the opposite. He was actually an agent, a professional service provider, marketing service provider, who owed fiduciary duties to my client, not vice versa. Through the judgment, just to draw your attention to the judge's conclusion that I was just going to invite you to bear in mind, it's the passage that starts at paragraph 94, so pages 3215. Can I ask you to look at paragraphs 94 and 95?
Yes, I've read them and highlighted them.
Okay. The point really here is that Mr. Justice French was satisfied, you can see at paragraph 95, that Mr. Fontmante's and his counsel's submissions as to the true interpretation of the agreement. Obviously, in this case, he was focused particularly on the allegations about co-branding for a period of 10 years. He said that does not make commercial sense, and in my opinion, is untenable. Counsel for the claimant has pressed his constructional arguments with nicety. However, in my opinion, the construction for which he contends has no real prospect of being accepted in a contest for final relief. There's something inherently uncommercial about the proposition the defendant agreed to be locked in for the term of the agreement to co-branding with the claimant, whose role under the agreement was essentially a provider of marketing services to the defendant. Now, just pausing there, my learned friend, both in submissions and I think in his client's evidence, tries to highlight the fact that this was a judgment on an interlocutory application and therefore would not ordinarily be characterized as a final judgment following a trial. But taking matters at the very lowest from my client's point of view, this is a reasoned judgment of a judge of the DIFC court, who's a highly respected jurist, I think formerly of the High Court of Australia.
Chief Justice.
Chief Justice of the High Court of Australia, I apologise. And this court is entitled to treat this ruling as being certainly persuasive as a matter of authority, if not binding as a matter of authority on the matters which it determines.
But on the claim that's presently before me is not based on this dispute. there is one pleaded reference to it, which I will be asking Mr. Montague Smith to deal with in due course. I'm sure he will, at paragraph 29.3. Pursuant to clause 5.1g of the agreement, Sir was not entitled to rebrand Sir unilaterally and was obliged to incorporate L.l.c's branding into any branding of SIR. That assertion, on the face of it, flies in the face of Justice French's clear decision here in paragraphs 95 and 96. But the claim that is being pursued now is not based on that alleged breach. It's based on something entirely different. So why are you focusing so much, apart from your abuse point, on this judgment?
I'll have to come and explain it obviously more fully in due course, but to try and answer that right now. As it happens, in the pleadings and evidence in support of the application, there were a catalogue of complaints made which overlap with the current complaints. And so when we get into sort of Henderson and Henderson or abuse type arguments, there are, I suppose, three things to think of. One is there a raised judicata? Well, no, there's not, because there isn't a final and binding judgment that dismisses a claim for the fees. Totally accept that. But Henderson and Henderson abuse raises the question whether a party could or should have brought the complaint in the same proceeding, seeking the court's determination of that complaint to avoid the respondent being vexed twice with a further piece of litigation.
I'm well familiar with the principles, and the guiding principle for me, I've done many abuse cases. The best exposition of it, modern exposition of it, not surprisingly, is Lord Bingham in Johnson and Gore Wood. He basically gives a judge a vade mecum as to how to deal with these applications. And I tell you now that unless you persuade me to the contrary, that is the rubric that I will follow, having heard your submissions, in deciding whether there is abuse here. So I'm not being greatly helped at the moment by this reiteration of Justice French's interpretation of the contract. The real question is whether it was abusive. It is abusive not to have pursued the claim for the unpaid commissions, consideration, call it what you will, in that Part 8 proceeding before Justice French, and that it's abusive to be pursuing it now in these proceedings.
Well, if I may, I mean, I don't certainly disagree with you on the law. I'll come back to the actual abuse point, but the reason I'm showing this to you right now is because you need to understand, if it's not clear enough in our evidence, that once this judge gave this judgment, up until this point in time, my client had not accepted Mr. Fontmante's repudiatory breaches of the contract. But if you ask yourself, well, what has actually been going on in this period of time leading up to this ruling, you've had Mr. Fontmante drop a grenade in the lap of the court, destroying the relationship between the parties because he has chosen to breach the conflict resolution protocol and go to court, not only demanding an injunction in secret initially, but also making very serious allegations of fraud and dishonesty about non-payment of revenue, which he didn't ask the court to determine, but he saw fit to make the allegations in circumstances where he'd never seen fit to identify those complaints through the grievance process in the protocol.
I have that point. You've made that point very well, if I may say so.
But then can I then, in a sense, show you what happens next? Because because it's important. The reason this is actually most important to me, if I may say so, and to my client, is that it's critical to an understanding of the claim for aggravated damages. because it's one thing to have a case before this court in which a claimant is saying, look, we're both commercial parties. We have a genuine dispute between us as to the true meaning of a contract. Can the court please either declare the contract's true meaning or rectify it, or conclude that because the other side's got the contract interpretation wrong, they simply owe me a debt or a finite amount of contractual damages? That's one thing. That's the 20 million dirham claim. But here, Mr. Fontmante is suggesting, he's trying to plead a case to the effect that my client, which has no track record of criminality or dishonesty, is a reputable real estate agency with reputable principles, somehow has defrauded him and dishonestly breached a contract, thereby triggering some claim under Article 42 for hundreds of millions of dirham.
Mr. Potts, you seem to be suggesting that it's not open to a party to bring a claim against this eminent estate agency, Sotheby's, because of their repute. Whether it's a claim is open to them depends on the evidence. That is what I have to consider. It's not assisting me to tell me or to give me references for Sotheby's at this stage of the proceedings on this application.
I apologize. In a sense, that's a bit of jury advocacy, for which I apologize.
It's a lot of jury advocacy. I once was a jury advocate, so I do recognize jury advocacy, but that's not serving your clients well, if I may respectfully say so, at this stage. Focus on the fact that a claimant may have evidence. I'm not saying for a second it has or doesn't have. That's not my function at this stage of the proceedings. But the focus has to be on what are the planks, building bricks, call it what you will, of this claim. And you need to show me that they do not provide any reasonable prospects, any real prospects of succeeding in the claim. So please focus on that, not the good reputation of your clients.
Of course, but I'll have to come back to show you the pleaded claim for the aggregated damages. There's lots of different moving parts in this case. One has to look at iteratively. But if I can show you page 1784 of the bundle, which is the termination notice.
Yes.
And you'll see this at 1784. Dubai Sotheby's writes to L.l.c on the 28th of September. So this is now following the judgment of Mr. Justice French. And the notice is with immediate effect terminating the agreement. The references then are to various provisions of the contract law and the implied terms in contracts law, as well as to the express and implied provision of the agreement. We have no option but to accept your repudiated and renunciated breaches of non-performance or obligation under the agreement. Now, without prejudice to all the grounds on which we're entitled to terminate the agreement, we note in particular. Now, these are important points to have in mind because these are all essentially overlooked or ignored by the claimant. Since 25th April 2023 to date, you've acted in repudiated breach of the agreement by deliberately, intentionally, or recklessly refusing to comply with your contractual obligations as a marketing and branding service provider agent to facilitate our proposed rebranding exercise, as was first requested by letter dated 25th of April, repeated on numerous occasions since then. As you well know, the DIFC court has held by its order and judgment, your asserted position has at all material times been legally unsustainable. And this is a matter which can come as no surprise to you, since we repeatedly explained this to you directly ourselves. So if I can just pause there, I've shown you the judgment of Mr. Justice French, which makes clear that the claimant's interpretation couldn't even withstand scrutiny and had no real prospect of success. The consequence was that since April of that year, the claimant had been refusing to do that which was being asked of him as a marketing service provider, which was to facilitate the rebranding. And he'd done that in circumstances where he hadn't gone through the dispute resolution process, but he'd then applied urgently and in secret for an injunction, which he didn't get. He forced my client to give temporary undertakings to preserve the status quo for a short period of time to facilitate the resolution of this issue before the judge. And against the background of that, he'd made a whole host of allegations which were obviously disputed, but very serious and aggressive, and not the subject of the dispute resolution process. So the letter goes on at 1785. Since then, you've wrongly, repeatedly, and unreasonably sought to promote your own interests above our interests, despite your contractual obligations under the agreement as our agent. 3, the necessary relationship of trust and confidence is entirely broken down between us as a direct result of your breach of the contract since April 2023 and today's date, as a direct result of your unreasonable and unjustified demands to renegotiate the terms of our agreement. Further, alternatively, the necessary relation of trust and confidence is entirely broken down between us as a direct result of your false and misconceived allegations of deceit and or contempt of court. I haven't really focused on this, but there were suggestions being made to the judge that there'd been some contempt by alleged breach of the undertaking, which was never established and not pursued. And then the question was made, we require you to immediately return to us all of our confidential and proprietary documents, information and data, and all the personal, confidential, and proprietary documents, information, data belonging to any and all of our clients, employees, agents, or counterparties, and you immediately cease holding yourself out to any or third parties, our agent, you undertake in writing immediately to comply with these requests. Now, those are totally standard requests, actually, but important ones, given the sensitive nature of the data that is confidential to Sotheby's International Realty. Now, the letter, as it happened, was then followed up with a request from Al-Tamimi directed to the lawyers. Just bear with me while I find the reference to this. I just need to find the precise page reference, which will be in the exhibit to BT1. So I think if you look at it, please, at page, just bear with me 1 second. Yes, can I just ask you, please, I apologize, to look at page 1006, which is part of the exhibit to Mr. Tessera's first witness statement. At 1006, you should find a letter of the 3rd of October, 2023.
Yes, I have it.
That's from Al-Tamimi to the claimant's then solicitors, Hadef and Partners. The first bit of the letter was asking them to confirm whether they also represented Mr. Fontmante personally. At paragraph 3, what was said was that the agreement's been terminated the 28th of September. Our client has demanded your client immediately returns to our client all its confidential data, as well as access to social media accounts, provide appropriate undertakings in writing to our client. Your client and Mr. Fontmante have abjectly failed to comply with our requests and have instead proceeded to infringe intellectual property rights and our contractual rights by wrongly continuing to display our client's trading name on the website. And it goes on to make the complaints about the ongoing trading. And paragraph 4, there's evidence set out of all of that. Now, at paragraph 6, there's a request for sort of a cease and desist. But paragraph 7, the specific requests that were being made then include at 7.4 delivery up of any and all confidential data pertaining to our client or our client's business, maybe your client's Mr. Fontmante's possession, power, or control, and a request at 7.5 for an undertaking. Now, the draft undertaking is the one which you will find at page 1011. So that was what we were proposing should be signed and returned. And of the particular request for undertakings that your Lordship might focus on now, is the one at number 4, to deliver up all confidential data pertaining to SIR that may be in our possession, power, or control. Now, the response to this came on the 6th of October 2023 from Hadef and Partners. You'll see that at 1012.
Yes.
Now, they do not confirm acting for Mr. Fontmante personally, just for the company. At paragraph 3, they say the letter is sent without prejudice to our client's position with respect to notice. It's not except the notice of valid, notice of termination. Our client's rights in respect of termination are reserved. This letter is not to be considered acceptance of that termination. Then paragraph 4, your client's demands vis-a-vis intellectual property rights and confidential information have today, for the most part, been complied with. And then they set out instructions they've been given about how eventually the sort of website and trading was being stopped. So if you look at paragraph 5 at page 1013, as to your client's demands vis-a-vis the website, we're instructed our L.l.c is currently taking steps to remove any of our client's intellectual property information from the website. The arbitrary deadline in your letter is simply an impossible time frame. Such amendments will be implemented as soon as feasibly possible. For the avoidance of doubt, will be completed by notice on the 30th of October. Paragraph 6, as to your client's request for the delivery up of any confirmation information pertaining to your client, which I think it should mean confidential, we instruct our client is currently conducting a review of information that it holds, which may be deemed confidential to your client. And upon completion of that review, the identified information and documents will be delivered up to your client. Now, just pausing there, no confidential information has ever been delivered up to Sotheby's International Realty, despite that representation. Now, that's obviously important when it comes to the fact that what actually then happens is, if we look at page 1014, nine months or so go by before a new firm of solicitors appear on the scene, R.W.K. Goodman, purporting to represent L.l.c, and they identify at the background section on page 1014 the background to the dispute that's arisen involving the decision of Mr. Justice French. Now, they then reference the fact at 1015 that there was service of a notice under clause 19.1 of the agreement, both in relation to the rebranding dispute, in relation to dispute that's arisen concerning payment of partnership fees due under the agreement. Well, that was only given, that notice, essentially as a condition of progressing the injunction application, because no notice had been given prior to the injunction application. And then they say further notice requiring rectification of the matter within 14 days. And they set out, again, all the points they'd made before about the revenue claim. long series of allegations, which are largely those repeated now in the pleadings. What you will not find anywhere in this letter, though, is provision of the confidential material. Instead, what you find at page 1029 is a covering email in which you'll see at 1029 the disclosure is made that the claimant's been seeking third-party litigation funding. This is 1029, the email of the 13th of June.
Yes, I have it.
Okay. Second paragraph. We write to notify you that our client was indeed able to obtain third-party litigation funding to fully finance this dispute. Our client's fund is Arbitrium Litigation Financing, who've asked to be copied into all correspondence in relation to the dispute. All correspondence in relation to this dispute is sent by email to the following addresses. Now, just pausing there, it necessarily follows from this, indeed from the very fact they've been copied into that letter, that they have had disclosed to them all of my clients' confidential information, including...
I'm sorry, just to interrupt you for a moment, if I may. In relation to the claim that is now being pursued for non-payment of, as it's referred to in this correspondence, of partnership fees, and you are contending that, as I understand it, that is the material confidential information you are complaining about that has not been returned. Is that right? Material confidential information, the foundation of this claim for unpaid partnership fees, fraud, dishonesty, and deceit.
Well, I mean, without in turn going into every single confidential document without the benefit of a confidentiality club order in place, in summary, there are likely to be two sets of buckets of information which are confidential. One is client data relating to customers, property listings, and all that sort of bucket of information.
But that's got nothing to do with the foundation of this claim, has it?
It does.
I'm sorry, Mr. Potts, will you listen to me? The foundation of this claim is what you contend to be confidential, private information to the defendant concerning their revenues on which this claim is based. You are saying that is confidential information which ought to have been returned by Mr. Mante. It's not been returned, and it's now being used as the foundation of this claim. That's the point, is it not?
Well, it's quite difficult to separate the two, because if we get into the evidence that Mr. Fontmante's put in for this application, the revenue information identifies, for example, properties, sellers, clients, with respect to properties that are sold, generating fees. All those spreadsheets, which, again, I don't want to give evidence, but you can imagine that the CRM system, the customer relationship management system, is linked through to the accounting software. We're not just talking about numbers, raw numbers. As it happens, raw numbers are also confidential to my client. Now, they would be capable of being known to the two parties. They should not be disclosed to the world or to third-party litigation funders, the raw numbers, because that is confidential information to my client. But the raw numbers are attaching to them are details relating to transactions, clients, particular sums, particular properties.
Yes, I appreciate that. But the raw numbers, the issue in relation to this is that the raw numbers from which the gross revenue is extracted or represents the gross revenue, the claimant contends that it has a contractual right to that information. And so what I want to know is, what is your answer to that argument, one of Mr. Montague Smith's arguments, as to his entitlement to use this information, which he was contractually entitled to and had access to?
Well, I mean, the complete answer to it is that it's all confidential, and it's confidential in express terms under the agreement. It's also confidential as a matter of DIFC law, as a matter of necessary implication because the legislation provides for it. It's information that's been provided by a principal to its agent, with respect to which the agent owes fiduciary obligations. I have no difficulty, I would have no difficulty with the claimant itself in a appropriately confidential environment asserting claims in its own interest by reference to its own confidential information. The difficulty is when you publicize that information in a public court forum without first securing confidentiality safeguards in the classic form of confidentiality club order, directions from the court to preserve the confidentiality. But equally, there is nothing in any of these agreements or as a matter of law that would entitle a party to disclose any of that highly confidential data to an unidentified or as yet unidentified third-party litigation funder.
So the fundamental complaint is the disclosure to the third-party funder. That's what you're focusing on in this part of your submissions. Am I right?
Well, what we have clearly proven from this correspondence from the claimant himself is that confidential information has been disclosed to at least one or two third-party litigation funders without our consent. That is a breach of confidence, and clearly that is a breach of confidence that has then been relied upon in the bringing of the claim, because the claim has been brought, it seems, with the support of those litigation funders. Now, separately, we have actually requested return of all of our confidential information and were met with a promise from Hadef and Partners that it will be returned. And since then, nothing has been returned. Instead, it may have gone to competitors, we don't know. It's certainly gone to litigation funders. And on top of that, it has been deployed in a pleading and an evidence which has not previously been the subject of any confidentiality order or sealing order. And that, in our submission, is a catalogue of breaches of the obligation of confidentiality, which, by the way, need to be read in context of Mr. Fontmante's own evidence with statements of truth, although there's these inconsistencies which remain unexplained and an attempt to amend the pleading, as to his improper access and misuse of information held on databases belonging to the claimant. Now, there's a whole lot of other arguments about this claim to a contractual entitlement, because the claim to a contractual entitlement cannot survive termination of the contract. There might have been, while the contract was alive, an ongoing series of contractual rights to be provided with information or not, subject to the circumstances. In the same way, he was under an obligation to provide information. But once the contract is terminated, those contractual rights do not survive. They do not exist as at today's date. Trying to think if I can usefully show you any more in the chronology, although you've read all the evidence already. Can we go back to the particular claim before then bouncing back to the agreement and some of the relevant terms? So again, if you want to use the amended particular claim, I think it's 1629.
Yes.
I don't want to read out every paragraph in the pleading, but it is.
I have read it with obviously great care. If you just want to give me references, sure. I'll check that I've read the material and
So
Read it again.
So we'd looked at 7.1.6 at page 1636.
Yes.
Can I ask you to look at paragraph 7.2? 7.2, the assertion is pleaded that the partnership gave rise to a relation of trust and confidence where LXT and SIR became each other's fiduciaries in accordance with Article 1581 of the DIFC Law of Obligations. Now, there are then, I think, 5 matters set out to supposedly justify that assertion. We'll come on in due course to explain why this is a false logic and actually a logical impossibility for both the principal and the agent to be each other's fiduciaries. You then see at paragraphs 9 onwards the complaint that largely recites the matters set out in the correspondence, but which discloses to the world at large alleged revenue figures. Then at paragraphs 14 and 15, we have what we suggest are both incredible and improperly evidenced proposed amendments to the manner in which Mr. Font gained access to data and information for his own purposes. So you'll see that the original suggestion was that L.l.c accessed the customer relationship software.
Does this matter on your case? The fact is, somehow, by some means, he accessed it, he obtained it, he's used it. That's the nub of your case. That's the important feature, isn't it?
Precisely. But I think the position we rely on comes from his own evidence. But despite his own evidence, attempts have been made essentially to rewrite history as to what actually happened in this draft pleading.
He hasn't rewritten the key piece of history, which is that he got the information, he's used it, and he's founding his claim on it. His claim for unpaid share of gross revenue. That's really, isn't that all that you need for your foundation of misuse of confidential information?
I agree with that, my lord. I think that's maybe for my own friend to explain why this amendment is thought.
I'm sorry, but it just seems to me to be pointless prejudice raising at the moment. I've got to look at this analytically and see whether at this stage you have satisfied me. I'm not talking about the amendment now, whether you have satisfied me that there is no real prospect of success for the claim which is now mounted against your clients for a failure to pay the due share of gross revenue and the attendant causes of that alleged, which are knowingly, fraudulently, deceitfully, and so on. They avoided paying his or L.l.c's share of gross revenue on his case, on its case.
Obviously, we have lots of limbs to our application, and some of our application focuses not on just simply a binary analysis, is the claim good or bad? We're focused on particular allegations, such as, for example, the claim for interpretation on the theory of mistake, the proposed amendment to plead rectification, the claim for aggravated damages, the assertion that my client was a fiduciary somehow, and that somehow creates some additional alternative theory for the claimant.
Well, I'm conscious of all of these limbs, but we're focusing at the moment. I'm actually looking at the paragraphs that you've taken me to about revenue. So we're focusing on revenue here, which is why I've asked the question I have, which is essentially what is the point of rehearsing the different accounts for how Mr. Fontmante came into possession of this information? The important point is that he is using it. Can we focus on that and move on from that, please?
Well, I don't need to spend more time focusing on that fact.
Right.
I'll have to come back, I think, to the legal consequence of that fact.
Certainly, you do that.
And if you don't mind, I won't do that right now, not because I'm trying to dodge a question, but in the interest of time, what I'm trying to do actually is just make sure your lordship is focused on all the relevant paragraphs and the particulars of claim.
Yes.
To then be able to synthesize those with the relevant provisions in the contract before we then come back to the arguments. But the key, in a sense, is to understand the particulars of claim as steps or bricks in a building, because what it's trying to get to, not only in terms of identifying what it alleges is the position on revenue, is all premised, of course, on the proposition that the meaning of gross revenue is the meaning contended for by the claimant, and that the defendant knowingly accounted for things deliberately and differently. Now, that then gets you to, for example, the claim at paragraph 22 at page 1642 that seeks the historic payments in debt, alternatively as damages. And then at paragraph 23, there's an allegation which is essentially looking at the period between July 2023 and the date of this pleading. Then at paragraph 24, there's a suggestion that there's been loss and damage. And then we've got assertion in 24 that L.l.c's average cost of debt is 6% per year. And then that supposedly justifies a claim for losses for non-payment at that rate compounding annually.
Yes, it's the usual chestnut. Is it a claim for interest or a claim for damages represented by interest? You raised this at the beginning of your submissions when you.
I mean, some of these points in isolation would not be enough in isolation to trouble the court with. But the point is, you can see that from every paragraph of this pleading, an attempt is being made to aggravate the total value of the case. And we've got a professional service provider who's refused to give any disclosure of its finances for security for cost purposes, who's pleading the allegation that it has an average cost of debt of 6% per year, none of which is evidenced or justified anywhere. That's not, though, the main point. You'll see that 25 is, in this context, claims for compound or simple interest.
Yes.
Then we've got this building block to the case, which is the allegation that my client has unlawfully terminated the agreement. And you'll see this, section E, starting at paragraph 26, suggesting that between 20th of August and 27th of September, it's alleged that we took steps to prevent L.l.c from performing its obligations. But you only have to read that in conjunction with the Justice French's judgment to realize that this is simply not true, complete, or accurate statement of what actually happened. What actually happened, which is why I've shown you the termination notice, is that Mr. Fontmante deliberately refused to do his job. So,
your client's case is very clear on this. So be assured I have that point well in mind.
But it's, again, you go on to paragraphs 30 and 31. 30 and 31 are trying to frame an argument which is unarguably bad, that my client evinced an intention not to be bound by the agreement's terms and was in repudiatory breach, and that somehow L.l.c accept the repudiated breach and claim damages for wrongful termination. Now, just pausing there, it is relevant to note that there was nothing in any correspondence at any point in time in which L.l.c purported to accept repudiatory breach by my client. The first time that concept came into existence was through this particulars of claim. So despite us terminating because of its repudiatory breaches, which we can see clearly evidence in the court record and in the evidence, they come out of the blue to say, aha, we're going to allege that you've wrongfully terminated. And then at paragraph 32, what is alleged to follow from that is some further alleged loss and damage, looking forwards allegedly until 2030. Now, just pausing there, whatever one might say about L.l.c's complaint that it doesn't know the true figures historically. Now, as it happens, it's obviously put forward what it believes to be its case on the figures it knew about or the figures it alleges were the truer figures, all of which is premised on, we say, misinterpretation of gross revenue. But now there's this forward-looking projection of what is said to have been the future gross revenue, supposedly based on average revenues from the past, allegedly then the subject of some total present value calculation. And none of that, for example, just by way of example only, addresses the credit that would have to be given due to cost savings or the mitigation steps that have been taken or will be taken to mitigate against any alleged loss or damage. They're simply suggesting, well, we're going to imagine some fanciful future where we would have been paid some glorious amount of money over the next 7 years. And we're going to claim it all now as a lump sum on the basis of these figures. Now, I mean, none of this is substantiated by obviously any forensic accounting evidence or expert opinion evidence. It's all Mr. Fontmante's say-so, but it's essentially no more than wishful thinking. These are not properly particularized claims for damages, even when it comes to quantum, let alone causation, remoteness, mitigation, or fundamentally the issue of breach.
What about the point that he's not got access to the figures to do that at this stage? And they're doing the best they can to give an estimate, as often has to be done prior to discovery and expert evidence, quantifying a claim properly in claims of this type.
Well, it would be one thing to claim damages to be assessed, but that's not what's being done here. What's being suggested here is that these are the damages that they seek.
This is rather better than damages to be assessed. It's an attempt to give you an estimate.
Well, possibly, but the expenses, for example, that's suggested here. Can you look at?
I've already highlighted the expenses and the footnote as well. 55% of the fees.
Right, precisely. This is not, with respect, anything other than a contrived attempt to put in a headline figure, which we respectfully submit has only been done in order to either vex the defendant into a settlement, given the large size of the number, or to attract the support of the litigation funder. But it's not
I have that point well in mind. You've made that point several times in your statement and in your oral submission so far. Just one point on this argument about repudiation. What do you say about Mr. Montague Smith's point that if your clients were engaged in a very substantial fraud in concealing the true level of gross revenue and paying a much reduced amount deliberately, deceitfully, dishonestly, what do you say about the termination point, or the answer to your termination point that Mr. Montague Smith raises, that in effect the defendant cannot rely on its own wrong to claim that there has been a valid termination of the contract by it? That's as I understand it. He obviously may develop that and refine it, but in broad terms, that seems to be what he's saying. How do you deal with that?
I mean, obviously there is the prevention principle at law, and there's the L.l.c case, for example, as an illustration of that. But that's nothing to do with the facts of this case. In this case, I mean, obviously, it goes without saying that we deny the allegations of fraud. We can't even understand how they've been properly pleaded, given that the equally plausible inference, even if one were to assume in favor of the claimant that his interpretation is correct, but the equally plausible inference is a question of either innocent or negligent mistake rather than deliberate fraud. So it's very hard to see how you can allege fraud. I mean, you've got to put it all in context. Mr. Fontmante's company was paid 5 million dirham to purchase the company. He was paid an annual marketing fee of 2 million dirham, and then it increased to 3 million dirham. He was being paid, and the relationship was positive to the point that they were even negotiating over expanding the relationship, until he threw a grenade in the works by saying that he did not want to follow instructions when it came to rebranding. And then he sued. Now, the prevention principle point would only get my learned friend somewhere if the only reason that was being sought to invoke termination rights was my client's own clear breach. But that's not the only reason here. The primary reason was the fact that he was not following instructions. And it was never suggested. It was never suggested in any form of correspondence prior to his allegations in court that there'd been under-reporting or under-accounting of revenues. If he had
Sorry, I hesitate to interrupt. It's just we're now at 9:35 UK, 1:35
I'm sorry.
Dubai.
Thank you for reminding
So
me.
sorry, I didn't mean to interrupt. I just was trying to find a good moment.
Right. Well, I'll let Mr. Potts finish his answer to my question, and then we'll adjourn for the necessary time. Thank you for reminding me. You had me so enthralled, Mr. Potts, I missed the time.
Sorry. Well, I mean, I think that's probably enough for present purposes. If we break, what I wanted to come back to then is just page 1645 in the pleading to finish off the discussion of the claim for additional damages, for example.
Right. Well, that's a substantial matter, and I'll let you do that after the break, rather than put anybody, you or anybody else, under pressure at this stage. So, have you managed to take instructions from your those behind you or far away behind you, thousands of miles behind you, or ahead of you in Dubai in time? How long do you want? 45 minutes, an hour, what?
I think 45 minutes is fine by me, and I don't see any instructions to the contrary.
Right. Well, I'm going to say we'll start again at 10:30 UK time, so that will be 14:30 Dubai time, I think. Right. Thank you very much, everybody. We'll adjourn now. Right. Mr. Montague Smith is there now, and I presume his team and yours as well, Mr. Potts. So, ready to resume. You were taking me through the particulars of amended particulars of claim, which is what we're looking at, and you were about to deal with the. Pardon me. I had the page open and I've closed it.
It was 1645 that I'd referred to.
Thank you. Yes, I'm there again. The award pursuant to Article 40.2.
Although, at risk of disappointing you, can I just ask you to look at the page before, 1644?
Yes.
You look at paragraph 29.5.
Yes.
And you'll see that in this section of the pleading, where the complaint is being made that there's been unlawful termination, and in a sense the draftsperson is trying to justify L.l.c's behaviour, the suggestion is made at 29.5, L.l.c never demonstrated an intention not to abide by the terms of the agreement. To the contrary, L.l.c sought to enforce the terms of the agreement. The parties simply disagreed as to their meaning and effect. Now, just pausing there, the words I just want to focus on is the parties simply disagreed as to their meaning and effect. We obviously don't accept that this is a correct characterization of what the claimant was doing when applying for an injunction. But it's helpful to note that phrase, to have in mind a point that I will come back to, which is essentially, first of all, the concept of efficient breach, but secondly, the fact that in any contractual dispute, probably most contractual disputes actually, the parties simply disagree as to the meaning and effect of the contract. And in circumstances where the parties simply disagree as to the meaning and effect of a contract, it's quite a jump to then jump to what is pleaded at paragraph 33 and back to page 1645, that the allegation is put to justify an award under Article 42 that my client's conduct in breaching the agreement was deliberate and particularly egregious and offensive.
Well, that's conflating two different things, two different. The 29.5 that you referred to me to, and 29.3, which I believe I referred to earlier, those are focusing on the rebranding issue that was determined by Justice French to the extent that he did. What 33 is focusing on is the failure to pay the due proportion of gross revenue, allegedly in a dishonest, deceitful, and concealing manner. So it's two different things.
I of course, I appreciate that. I wasn't trying to suggest that the same thing. The point I'm making is that the pleaded case, it assumes that Sotheby's knew that it had a certain alleged obligation, and it deliberately and dishonestly breached that obligation with knowledge of the obligation. The point I'm making is, as I come on to explain, Sotheby's takes a diametrically opposed view as to what is the true meaning of the agreement. And on its face, the agreement, as indeed drafted, the express words it uses, is consistent with Sotheby's interpretation.
Is it consistent, or at least is there an arguable case about whether it's consistent with Sotheby's implementation of the agreement, where it is suggested, and I make no decisions whatsoever, it is suggested that Sotheby's were paying in accordance with the gross revenue generated by the buyer, albeit it was an understated gross revenue.
Well, I don't accept that, but I'll come on to explain
well,
why.
Of course you don't accept it. But pause a moment. Isn't that a matter for trial as to whether they were paying on the basis of its gross revenue, that is the buyer's gross revenue, Sotheby's gross revenue, and doesn't that go to the issues of interpretation of the contract or rectification of the contract that the court is going to have to determine? You're asking me to determine it in your client's favor on a summary basis now, and the claimants are saying it's a matter that should be determined at trial.
There are quite a few points, in a sense, to unpack there.
Yes.
Because one of them turns on the thesis that in the interpretation of this contract, the court should take into account what is alleged to have been the party's conduct after the contract was entered into. And what I'm going to come on to show you, if I may, is you have to read the contract with the amendment agreement, because the two documents are contractual documents. I have to show you what the amendment agreement actually says. Now, as it happens, because there's also an entire agreement clause in this contract, we take issue with the proposition that as a matter of DIFAC law interpretation, you would take into account post-contractual conduct. I appreciate that's what the legislation says, but here there's an entire agreement that essentially carves that out, we would say. But even if you were to look at...
It also says, the contract also says that we take into account the MOU as a contractual document.
Well, I'm not sure it says that, but there's a debate between the parties, as there was before Mr. Justice French, about the relevance of the MOU. But we would say when you actually look at what has happened here, my client has paid the fee that was, we say, correctly calculated for the correct years. And we have not been calculating it by reference to our client's gross revenue, but by reference to the gross revenue. Well, first of all, by reference to the fee, the fixed fee, and I'll come on to show you the amendment agreement that deals with that. And then in anticipation of the gross revenue attributable to the seller. So we actually don't respectfully submit that is a triable issue when you actually understand the documents and what actually happened.
Where is the calculation then that shows the gross revenue attributable to the seller's conduct in whatever it did under the agreement, and the demonstrated proportion of that being paid? Where do I find that? Because I look for that and I haven't seen anything to that effect.
Well, the document you need to look at, if I may point you to it.
Yes, please do.
It is the amendment agreement.
No, I'm looking for a calculation. There was a certain amount.
But the reason you don't need to look for that calculation is because if you look at the amendment agreement at paragraph 4, so page 60 of the bundle.
Is that 70? Adding
Sorry,
10.
It's red numbering 60, so that would be, I suppose, 70. Is that correct?
Yeah. Yes. Yes. It is. I have amendment number 1 open. Yes.
So, can you see that there were these amendments at paragraphs 1 and 2?
Yes.
And then at 3, there was a discussion about meeting to discuss performance and to review the partnership fee moving forward. And then 4, as defined in the original agreement, the partnership fees we paid by the buyer in advance on a monthly basis via bank transfer to the seller during the first 5 working days of every month. From the 1st September 2021 to the 31st of August 2022, the monthly payment will be 250,000 dirham. And from the 1st September 2022, the monthly payment will be 200,000 dirham, unless agreed otherwise. That was fixing the amount payable for those years by agreement.
Yes, go on.
So it wasn't the case that there was any need to calculate some different amount for this period of time. The amount was fixed by agreement in the amendment agreement. And equally, it required some additional or separate agreement to calculate any different figure. Now, my learned friend, I think, has only one illustration, which is very debatable on the numbers, it seems, where he suggests that his client issued a separate invoice for what he said was 5% of revenue figures in excess of 40 million, in addition to the monthly fee that was paid. But it's important to note that there is nothing in any of these agreements that dictates the deadline by which any such figure should or would have to be paid or agreed. There's nothing about that temporally.
Well, was there, just clarify for me, was there not an annual statement or a periodic statement, I'll say, because I'm not sure of the intervals. Was there not a periodic statement by Sotheby's of the amount of its gross revenue during the years in dispute before termination? Let's say.
Well, the evidence is a little bit opaque on this, because what the evidence suggests was happening was that the figures were available through Google spreadsheets, fully transparently available through Google spreadsheets that were available to the claimant.
Yes.
And the claimant was the person who had the obligation. If you can look, please. I mean, in a sense, we can come back to this pleading about the deliberate thing. But if we look at the agreement, one aspect of the claimant's case, which is has no answer to this, simply ignores this point. If you look at page 38, using red numbering 38 of the agreement.
Sorry, is that you're taking me to the original agreement?
The original agreement.
Right. Yes. Yes, I've got that. 38. Yeah.
So it's clause 5M. Clause 5M at the top of 38.
Sorry, it's page 48.
Sorry, 48.
Yeah, in my bundle.
Does your lordship have clause 5M?
Yes, I have that. Yeah.
And we'll have to look through all the clauses, but clause 5M, the seller, L.l.c, will provide a detailed reporting on a quarterly basis, including the website traffic evolution, traffic sources per channel, number of leads per channel, both online and offline, cost per lead and channel, and also transactions and revenues generated from each channel. During the first 6 months of the partnership, the reporting will be bi-monthly. So it was the seller that had the obligation to provide the data that would enable the parties to work out what revenue had been generated attributable to the seller.
But just pause a moment. I'm obviously missing something, or I'm being confused. Did not the defendant, Sotheby's, provide spreadsheets or some form of document showing what the gross revenue, what it said was the gross revenue of its business, periodically was to the claimant?
I think the shorter answer to that is no, but it's slightly more nuanced. But it may be that this is dealt with or attempted to be dealt with by Mr. Fontmante in his exhibit. He has produced various documents which are not contemporaneous documents. But if you were to look through, for example, his exhibit, so if you can go to page 1128 of the bundle.
Is that 1138 for me?
Sorry, it's 1118 in the red.
Right, okay.
So I think it'd be 1128.
Yes, I have it. Yeah.
So here is a spreadsheet, which is, I think, a print off of one of the Google spreadsheets that was simultaneously made available by my client to the claimant, because the claimant had access through the CRM and accounting software. And if you look at the transactions here, you'll see that there is a column, the second column, which identifies the lead source. And if you, for example, were to go down to maybe the 10th or so, you'll see one referring to luxhabitat.ae. And a bit further down, maybe 2/3 of the way down, luxhabitat.ae website organic. And then there are dates, transaction prices, commissions, percentage paid, and so forth.
Yes.
Now, of this information, you can see that the source, the lead source, is being attributed either to the seller, Lux Habitat, L.l.c, or to other sources. So that information is all readily available, was readily available, and indeed not only was it readily available, it was the seller, L.l.c, who was obliged to provide these detailed reports on a quarterly basis, identifying what in fact was being generated through its channels or not through its channels. Now, what then Mr. Fontmante has sought to put in to the bundle is at page 1146, the red, it's 1156 in the bundle.
Yes.
And you see that he has put in a invoice where he has calculated what he suggests was an amount payable.
Sorry, I obviously got the wrong number. You said 1156. This is a
sorry, it should be
letter of intent.
Yeah, sorry. Using the red numbers, it's
Yeah.
1146. 1146.
1146. Yes.
And this may be, I think, what your lordship had picked up on through pre-reading, perhaps. This is an invoice from the claimant to the defendant, dated the 16th September, where there is an invoice for 5% over target marketing fee, with 366,000 dirham being referenced. And then there is his production of documents, which is not a contemporaneous document produced by my client, but it's his production of documents, where he's produced the next two pages, 1147, two supposed separations out of gross revenue from SIR sales agents and then revenue from L.l.c's former sales agents.
So this invoice that you've just taken me to, was that paid?
He says it was paid because if you then look at his bank statements, he says, if you look at page 1149, so the next page, towards the very bottom of the page, you'll see there's a line item, which is a check deposit, the 647,745.
Yes. And
he, I think, in his evidence, has tried to calculate that as being the 366,900 plus, I think, 200 or 250 plus his calculation of VAT.
And what do you say it was?
Well, I frankly, we don't know how it was calculated, but that's not the really important point. The important point is that we suggest that the figure that we understood we were paying was actually calculated by reference to his sales agent's calculation. So if you look at page 1148,
yes,
this is L.l.c's former sales agent's report. You'll see the total is 7.4 million dirham.
And so we've got these two figures. They're not the same. Isn't this something that manifestly is going to have to be resolved by oral evidence at trial? This is just one illustration.
Well, there is a dispute on the parties' witness statements before you about this particular one-off payment. But the point I'm making is you don't really need to worry about that, because under this contract, we have an entire agreement clause. And under this contract with the amendment, we have a specific paragraph, paragraph 4, which deals with the amount that was due to be paid on a monthly basis.
But that wasn't what was paid. There was a figure paid here, you've just shown it to me, of 647,745, and you've not explained to me what that payment was for.
No, but that related to a historic year. And the concern we're dealing with is what was due to be paid for the years 2021, 1 September to 31 August 2022, and then from 1 September 2022 moving forwards. And that's specifically dealt with in paragraph 4 of the amendment agreement. This doesn't tell you at all. This doesn't tell you at all how you are meant to interpret the agreement with the amendment agreement. And the amendment agreement is a valid agreement. Now, he says that this was showing you what the sort of the variable figure he wanted to claim on his invoice was for the prior year, 2022-2021. But as it happens, it's just as consistent with our analysis, which is this was rewarding him for 5% of the value of revenue generated by the seller, not 5% total. But the court can't determine that particular dispute on the evidence in isolation, but it doesn't need to, because you can see from the actual contract documents that this doesn't assist at all in identifying what indeed is the true approach under the agreement as amended to the amounts payable. Now, that's obviously, in a sense, I think the answer to that point, that there's a slight dispute.
Well, I'll be frank with you. I'm not sure it is an answer to the point or the question that I've asked. You've not demonstrated to me how a figure in a check which came from your clients of 647,745 was calculated.
Well, the place to look for that is in the witness statement of Mr. Tercera. Let me just find the passage. Just bear with me 1 second. So it's page, using the red numbers, it's 1613.
Thank you.
Or you might want to pick it up just sorry, the page before, 16112 at the bottom. So if you can read his paragraph 3.
33. 33. Do you mean?
Sorry. His paragraph 33 to 35. That's his response to this evidence.
Yes, I've read that. I think as far as I need to.
Okay, so I mean, what I really want to do, which is the meat of the submission, is to try and take your lordship through the contract terms.
Yes.
Because we do suggest when you read them and understand how they work, the rest of the submissions fall into place. But before I do that, just to go back to I mean, you've read the aggravated damages passage of the pleading.
Yes, I have.
Just 2 points to highlight, if I may. So if we go just back to where we were in that. The thesis under Article 42 is that there has been a deliberate breach, a knowing deliberate breach of a contractual obligation, and that's particularly egregious and offensive. And then particulars are provided at paragraph 33(1) onwards.
Yes.
And the first point at 33.1 is the assertion that L.l.c. had limited means to check the reports. Now, we obviously say that can't make any sense because it itself had access to the relevant software, and it itself had an obligation to report on the different channels of revenue generation. Then just jumping forwards, 33.3, the assertion is made that the company SIR itself knew its reports to be false. Then 33.3.4, the assertion that it knew that the gross revenue was being misreported. And then at 33.3.7 at page 1647, the assertion in conclusion following these paragraphs is the magnitude of the underreporting was egregious and cannot be explained through an innocent error. It was deliberate and dishonest. So the pleaded case is to the effect that there is no possible explanation other than deliberate and dishonest fraud. And the point I'm making to your lordship is essentially that there is, on the evidence before the court, clearly an alternative theory, two alternative theories. One is your interpretation of the contract is wrong. The second alternative is that your interpretation of the contract is capable of legitimate debate. Because of the existence of those two possibilities, clearly on the evidence and on the face of the contract, and in light of the claimant's own pleaded case, that the contract either has to be reinterpreted on the basis it contains a manifest error, or rectified on the basis that it simply does not represent the intended agreement, it is a complete legal non sequitur to plead an argument that the breach was egregious and cannot be explained by innocent error. But there is a further series of non sequiturs, but to summarize, if you can look at page 1649, so paragraphs 33.14.
Yes.
There's the prior pleading of the alleged supposed unlawful termination by SIR, but it goes on to say at 33.14, SIR terminated the agreement unlawfully through the termination notice, consistently with its deliberate strategy to remove L.l.c. and prevent it from earning further revenues. And then 33.15, all of these acts took place in circumstances where SIR allegedly owed fiduciary duties to L.l.c. in breach of these fiduciary duties. Now just pausing there, when you look at the really uncontrovertible evidence as to what actually happened leading up to the French judgment and the termination notice, it's quite obviously a non sequitur to plead the assertion that represents or reflects a deliberate strategy on the part of my client to remove L.l.c. Equally, it's complete non sequitur, first of all, to allege that SIR owed fiduciary duties. It's a most unusual proposition that a client would itself owe fiduciary obligations to the contractor rather than the other way around. But to suggest that it somehow breached fiduciary duties, such as to justify this allegation of a deliberate breach in egregious circumstances. Now, the final point, just to note on this pleading, is the conclusory assertion at paragraph 34 that the claim for these supposed further exceptional damages should be quantified in the pleading as being 2 times the total amounts claimed above. Because the only proper sort of pleading, if one was serious about advancing this claim, would be to have said damages to be assessed, and then any additional damages in the discretion of the court to be assessed. It is quite improper, we suggest, to be deliberately exaggerating the quantified part of the claim to as high a number as possible, simply for the purpose of then inserting a further pleading that goes to the maximum possible amount contemplated potentially by the law, and say that should be multiplied by 2 to result in this extra fixed amount.
Just remind me, what does Article 42 permit? Up to 3 times, is it?
So it's Article 42. Yeah, it's referenced in our skeleton, but
yes, I know.
It says the court may, in its discretion, on application of a claimant and where warranted in the circumstances, award damages to an aggrieved party in an amount no greater than 3 times the actual damages, where it appears to the court the defendant's conduct producing actual damages was deliberate and particularly egregious or offensive.
So what's wrong with the claimant having a stab at what it thinks to be the degree of egregiousness and confining its claim to 2 times rather than going for 3 times? Why should it not do that when the law permits a multiple of damages to be awarded in these circumstances that are alleged? What is wrong about a claimant saying, we think this is particularly bad and egregious, not quite as bad as it might be, so we're going to go for 2 times. That's what we're going to argue before the court. What's wrong with that?
Sorry, I maybe we're slightly cross purposes. I mean, that there are a lot of things wrong with it legally. I've come back to about breach of contract claims. There are, we submit, quite obvious policy considerations that inform the law.
I've read all of that in your Skeleton argument. I've read all of that, but allowing for all of that, what is wrong with a party pleading its case for additional damages? I also note your very careful and reserved description of this as either aggravated damages or punitive damages or whatever else it may be called in other jurisdictions. But what is wrong with a claimant specifically plumping for a measure that it considers to be appropriate, that it will argue before the court is appropriate, as they do in America, for example, when they claim punitive damages, penal damages in some states, they specify a figure. And the figure is often related to a multiple of the compensatory damages. So I take all of your points about you claim alleged illegitimacy of this claim and the purposes, the illicit purposes for which it has been introduced to get a third-party funder on board, to terrify the defendant and so on into a settlement. I have all of that on board. But what is wrong with this form of pleading in 34, paragraph 34?
Okay, well, in the abstract, what is wrong with it is that the power of the court to assess damages in this respect are discretionary, and it gives the court, assuming this is available in breach of contract claims, the discretion both as to the multiplier and as to the multiplicand. And the correct approach in those circumstances, in the same way one would be pleading an unliquidated damages claim conventionally, would be to plead damages to be assessed.
Very well, I have your point.
And the reason for that, if you ask why is it wrong, the reason that it's wrong is because it's inconsistent with the overriding objective, and it actually makes a case commercially unsettlable. If a party produces a pleading whereby it keeps adding up on an artificial basis in an exaggerated way, damage after damage after damage, with compound interest or compound damage after damage, and it becomes increasingly divorced from the reality of compensatory damages, for it then to take as large a multiplier or multiplicand as it can.
Not as large as it could have done. It could have gone for 3.
Could have gone for 3, but it still produced an overall claim of $110 million, which is out of all recognition to the compensatory damages that would flow if indeed one could demonstrate that there had been a breach of contract associated with either terminating or allegedly not paying some differential. And it's divorced from reality in our respectful submission. The problem is that if the court doesn't grasp the nettle now, we all have to litigate this case as if it's genuinely worth $110 million.
Well, if the claimant's case is true, that there was a design in Sotheby's to expropriate L.l.c from its revenue, the revenues to which it was entitled, I appreciate all of your arguments that it has no such claim, that there was no such scheme and design, no such concealment, no such deceit, and so forth. But if the claimants were able to establish those facts, then this is what the law of the DIFC provides for a remedy, no doubt on public policy grounds, to deter such conduct in commercial parties, operating in the DIFC. So why is it so improper to actually mount the claim in the way that it has been done if the claimant can actually lead evidence to show that this is what has been done by the defendant?
Perhaps we're at cross purposes here. I mean, we're applying for strikeout and immediate judgment on the basis of the pleadings and the available evidence to the court.
Yes.
Of course, the claimant has alleged a wholesale deliberate fraud. And the problem with that is it's divorced from the reality of the case, because so many elements to its building block, to what it says is the only possible conclusion for the court, can be summarily demonstrated to be completely false. They're on a false premise, legally and evidentially. That they completely mischaracterize what actually happened as a matter of court record in front of Mr. Justice French. So once the court knows that, the court can't simply shrug its shoulders and say, well, any claimant can come to court on any given day to allege fraud in this jurisdiction and claim hundreds of millions of dollars, and we'll just let that move forward towards trial.
You keep going back to the judgment of Mr. Justice French. That is not an issue so far as the fundamental substance of this claim is concerned for a fraudulent non-payment of revenue or share of revenue to which the claimant was entitled. Well, at least up to the termination date.
Up until the termination date, we have what has been pleaded as a allegation that they're entitled to X, but they only got Y. And that is a pure breach of contract dispute. Right? And one could look at the pleading and say, okay, you're claiming 20 million based on your argument that gross revenue means this, but we dispute that because gross revenue means Y. But from the moment that they then say, okay, let's try it on with some litigation funders behind us to amplify the claim value here, let's do it by looking forwards, by suggesting we would have got paid X over 10 years. And that is premised essentially on the termination being unlawful, which in turn is premised on essentially ignoring what has actually happened between April and September of that year, where in reality, any fair assessment of that correspondence, as well as the evidence before the court, as well as the judge's judgment, is that the claimant got this completely wrong and the claimant refused to comply with its obligations.
I have your case in point on that, which is why I asked you the question earlier about what if it is the case, and if it was proved that the defendant was engaging in this fraudulent strategy to get him out, to get Mr. Mante, it's L.l.c, I know, but the actual players are Mr. Mante and the owners of Sotheby's, the defendants, to get him out of the business, to change the branding strategy as part of that stratagem, to deny him his share going forward of the profits on his interpretation of the contract or a rectified contract, whatever it may be. That's why I asked you the question, where does the termination, which on the face of it appears to be, you say, the claimant's repudiation of the contract, refusing to perform what he was required to do under it, what is the impact of, at the background, as the background to all of this, a fraud being perpetrated by Sotheby's against him?
Well, I've got some other ground to cover, so if I can't assist to answer the question, then just please cut me short. But it's important to remember that the claim is a claim for breach of contract. This is not a claim in the tort of deceit or for a breach of an obligation under the law of obligations analogous to the tort of deceit or a claim in fraud. That is not it. But the claim is a claim for breach of contract. And the contractual breach that is asserted currently is the allegation that we failed to pay gross revenue in accordance with his interpretation of the alleged contract. And we maintain that we have, in fact, by the way, paid you 5 million dirham to buy your company. And we have, in fact, paid you handsomely to perform marketing services. But unfortunately, before we had to pay you anything more, you started agitating for more. And not only that, you then decided not to do what the contract clearly requires you to do, which is cooperate with rebranding our business.
Right. Well,
And once you get to that sort of proper understanding of what the case is all about, is that there is now a second dispute being raised by Mr. Fontmanti as to what he alleges is the true meaning of the contract, and we say he's wrong about it. Even if he's wrong, the court can properly infer there's a reasonable disagreement that I'll come on to explain. And at that point, this notion that there's been some contrived fraud is completely unrealistic. But before I move on then to the contract, just one final point my instructing solicitors have kindly reminded me of, and I may have got this wrong. When you actually look at Article 42, it probably admits of two interpretations about the multiple, because when we go into the contract law in further detail, you'll see how it discusses compensatory damages being the concept. Article 42, which doesn't sit in the contractual damages section, but is in a remedies section, provides the court may award damages in an amount no greater than 3 times. Now, the way I sort of initially answered your question without thinking it through fully was that could mean they could claim triple, but actually you're limited in aggregate to triple. So by claiming double in addition to the actual damage, it is triple.
Right.
So,
Very well.
That's my instructing solicitor who has actually pointed out that is the maximum amount that they could claim. So I wouldn't suggest they should take credit from the notion they've limited their claim somewhat.
No. And I think I recall that point is made in the claimant's skeleton argument or in argument in evidence. There's an awful lot of argument in the witness evidence on both sides in this case.
So now without all that sort of attempt to give you some background about the pleadings, the history, can I just now look at the contract before then turning to the argument?
Yes, do please.
The contract that we've been looking at, I suppose, starts at red numbers 27. A couple of key features, if I can try and take you through what I submit you need to focus on. At page
37 in my bundle, but
okay,
carry on.
37. So if we go to page 39.
Yes, I have it.
The first point to note is that the word "the seller" follows immediately after the description of L.l.c Real Estate Broker L.l.c.
Yes.
So that is analogous to defining the identity of the seller. And then just beneath it, after defining my client as the buyer, it says each a party and together the parties.
Yes.
Now, we then see the preamble, the background section. Now, the background identifies the historic memorandum of understanding outlining initial intentions, but it acknowledges that they hereby enter this agreement to finalize their full understanding. C, the buyer, as per this agreement, has agreed to take over the sales team and agents of the seller's business, and in addition to this, the seller shall provide marketing branding support as defined below, as per the terms and conditions of this agreement. Now, over the page, it's agreed as follows. In interpretation section, at red 30 or bundle 40, business means the business of the seller as carried out by the seller.
Yeah.
Business contracts means the contracts, engagements, or orders entered into on a private execution of this agreement on behalf of the seller in relation to the business with third parties in the ordinary course of the business which are outstanding remain to be performed in whole or in part on the closing date. Now, business information means all information, know-how, and techniques which in any relate to all or part of the business, including or limited to documentation, data, manuals, customer lists, sales and marketing information, operations and management information, and financial information. If we drop down to gross revenue, the definition, gross revenue is the total amount of monies generated per year by the seller and any other affiliated companies, subsidiaries, or employees prior to any deduction.
Sorry, pause there a moment. Did L.l.c have any subsidiary companies?
I don't know the answer to that. My guess is no, but I don't know. Nobody's focused on that for present purposes. It might have done, I suppose, or it might have. It certainly had employees. It certainly had employees of its own, which it retained because it had. Although it didn't.
I was going to ask you the same question about subsidiaries, and nobody's focused on it. But obviously it is, and any other affiliated companies, subsidiaries, or employees of it. Employees, yes, is obvious to me on the evidence. It had employees. It was transferring those employees over to the buyer. But if the L.l.c did not have any other affiliated companies or subsidiaries, the next question is, did the buyer have affiliated companies or subsidiaries? Why would they provide for objectively? Why would these parties provide for revenue coming from affiliated companies or subsidiaries of the seller if it didn't have any?
Well, not sure I give you a complete answer to this party's subjective intentions, but can I offer you an objective analysis?
No, it's not. I'm not. This is not subjective. I forgot to put in the word objectively. The question is objectively. Why would parties who know, are likely to be taken to know, what the corporate structures of the respective parties are, if the buyer has affiliated companies and subsidiaries, objectively, it might indicate that that is what is being the parties intended to refer to, where they've used the word seller by mistake, as is alleged, not making any decisions on it. But it's an important question to ask, did the buyer have affiliated companies or subsidiaries? Obviously, they both had employees.
Well, sorry, can I just sort of
you can come back to answer that question.
I may have to come back to you, but we need to read the whole agreement. But two points I just want to identify is that, as we just saw, what was being transferred by way of the sale effectively was the sales agents and the sales team that previously were employed by L.l.c, but were now going to be employed by SIR. But L.l.c itself retained some of its own employees, and it retained its own separate corporate existence, because from the point of the sale onwards, it transitioned from being a real estate agency business with sales agents to being a marketing services consultant. So Mr. Fontmante's focus now was on IT, for example, and website management and marketing and so forth. But he had a number of employees who still worked for him, who stayed with him.
Yeah, not the sales agents.
Not the sales agents, other employees.
Backroom team, perhaps one might describe them as.
Well, I mean,
techies.
IT people, the IT crowd, whatever you want to describe them as. And the point is, if one imagines a brand new future where websites are important in the marketing and sales process, his company is going to be generating opportunities through the website, for example, and the draftsman of this document is going to be thinking, well, we want to capture not just the seller as a corporate entity, but we want to capture its employees, its agents, in whatever form they might be described, and we're going to therefore refer to their corporate subsidiaries and their corporate affiliates. Because in business generally, without reference to the facts of any particular case, it is perfectly conceivable that over the lifetime of a contract, a party contracts through its employees, its directors, its servants, or its agents. And so I don't think there's any evidence to suggest that either party went through a due diligence exercise to identify who were at the given moment in time the subsidiaries or the affiliates or the employees.
So it's belt and braces drafting that really means nothing.
Well, it does mean something.
Contingent drafting.
The reason it means something is because it explains actually the use of the word combined in the clause we'll come on to look at. Because in the clause we're going to look at, combined gross revenue is a reference to the combination of revenue generated by the seller and any of the seller's affiliates, subsidiaries, or employees. That's what's being combined.
Right.
Now,
you're going to come to that.
But the other key word to stress in this definition of gross revenue, in addition to the express reference to a defined provision, which is seller, and self-evidently not buyer, is that what is being talked about is the total amount of monies generated per year. It's not being received or paid, but generated. And then it includes, but not limits it to, various examples: commissions from any property transactions, referrals from third parties, any other income the company receives from its customers and partners for its products and services. Now, then we see the definition of KPI at page 31 of the red numbering: marketing branding support, meaning the marketing and branding support to be given by the seller to the buyer for the business. Definition of sales team agents means individuals in the seller's sales and operations team whose details listed in Schedule 2 of this agreement. And then we have at clause 1.2 a definitional section dealing with, amongst other things, the meaning of the word subsidiary. And here it provides that a company is a subsidiary of another company, its holding company, if that other company holds a majority of voting rights in it, or as a member of it has the right to appoint or remove a majority of its board, or as a member of it and controls alone, pursuant to agreement with other shareholders and members, a majority of the voting rights in it, or if it's a subsidiary of a company which is itself a subsidiary of that other company. So just pausing there, subsidiary is defined, but affiliate is not. But subsidiary is quite specifically focused on the corporate concept of one company being a parent of another, or the other being a subsidiary of the other. It's not talking about individuals who may be beneficial owners, for example. We can then drop down, please, to clause 1.11, which is at page 32, using the red numbering. Clause 1.11 provides that this agreement supersedes all earlier agreements, written or otherwise, between any of the parties or their respective affiliates relating to the subject matter of this agreement. And if you just note that provision, but we jump forwards to the entire agreement clause at page 41, using the red numbering. Clause 14, entire agreement, consistent with clause 1.11. This agreement, together with the documents referred to in it, constitutes the entire agreement between the parties and supersedes and extinguishes all previous discussions, correspondence, negotiations, drafts, agreements, promises, assurances, warranties, representations, understandings between them, whether written or oral, relating to its subject matter. 14.2, each party agrees it shall have no remedies in respect of any statement, representation, assurance, or warranty, whether made innocent or negligently, that is not set out in this agreement. Each party agrees it shall have no claim for innocent or negligent misrep or negligent misstatement based on any statement in the agreement. Nothing in the clause shall limit or exclude liability for fraud. Now, obviously, you could say there's a bit of circularity in DIFC law if the position being taken on the DIFC law is that because the law of contract enables you to look at pre-contractual negotiations or post-contractual conduct, you look at that with a view to understanding what's meant by the entire agreement clause. But the entire agreement clause, you would say, is a contractual term that the parties have specifically agreed to prevent the parties under DIFC law wading through the thicket of pre-contractual negotiations to understand what the contract is intended to mean. So we would say it has primacy by agreement over the provision that points the court to those factors in the process of interpretation. Now, you'll see that at page 33, clause 2, there were certain aspects of the seller's business that were not passing across with the purchase. And so it wasn't, for example, buying at 2.1c the seller's license, brand, website, domain name, assets, records, and such materials under the name and control of the seller unless accepted in writing by the seller. So it's 2.1c.
Yes, I'm just making a note.
Yeah. Now, we don't need to worry too much about the conditions precedent, but it's worth noting that there was a deposit of 1 million dirhams in the pre-contractual phase,
Yes.
which was treated as having been received. You'll see it clause 3.2. Now, when we look at clause 4, and before we then look at clause 5, it's important to understand that there were two essentially separate parts to this deal. One was the purchase of the business, and a separate part of the deal was the future provision of marketing services. So clause 4 is dealing with the purchase of the business. 4.1, the total consideration of the business will be 5 million dirham, the consideration, of which 1 million has already been received by the seller from the buyer. The balance of 4 million dirham will be payable by the buyer to the seller as follows. So there is now this sort of earn-out mechanism for the balance of 4 million. You'll see that A provided for 500,000 dirham on a post-dated check, and that's actually exhibited as an exhibit to the agreement.
Yeah, I've seen it.
Then at B, there's another 500,000 post-dated check. And then C, the balance amount of 3 million dirham was meant to be in the form of a seller note with a 3-year term. The seller note will be paid down via contractual payment at the end of the first, second, and third years to commence from the closing date, and be based on the overall business of the parties, which most importantly will include Gulf Sotheby's and Lux Habitat. The seller note will be paid as follows. Now, it's very important to understand these clauses and distinguish them from the clauses we see at clause 5. These provide that if the combined gross revenue per year of the parties is more than 28 million dirham and less than 35, the buyer will pay 1 million dirham a year until satisfying the seller note. And then 2 provides that if the combined gross revenue per year of the parties, the buyer will pay 2 million a year. But if 3, the combined gross revenue per year of the parties is less than 28 million, the buyer will not pay anything, and the pending amount will be accumulated for the following years.
What does that mean? Will be accumulated. The buyer will not pay anything, and the pending amount will be accumulated for the following years. That's the pending amount of the 3 million, is it?
Precisely. So the balance of 3 million, essentially, this is a clause that does actually track the performance of the combined parties' revenue, because you can see the reference to the combined gross revenue per year of the parties, including both Gulf Sotheby's and Lux Habitat. But if I mean, bear in mind this was COVID. This deal was done after COVID had just hit, and so the parties were naturally going to be cautious about the prospects of achieving these targets. And so what the buyer was doing is saying, well, I'm going to essentially borrow from you the 3 million, but you're going to get it on an accelerated basis if we do really well. It will be on a deferred basis if we do badly. But the key feature to note is this is the 5 million for the purchase of the business. And in this section of the contract, it's talking about the gross revenue per year of the parties, i.e., we've seen from the introduction the reference to that meaning both parties.
Yes.
Together the parties. Then you see at D, in case the buyer satisfies the seller note before the period of 3 years, the seller note will be considered settled. All amounts will be payable 30 calendar days after the end of each year from the closing date. At the end of third year, if there's any shortfall in paying the balance amount of the seller note, any remaining unpaid balance of the seller note will be satisfied by the buyer within 30 calendar days from the expiry of the third year.
So a long stop for the payment of the 3 million outstanding.
Right, and to illustrate some of the points I made earlier, which might be jury points, but can you look at G? G.
Yes.
My client actually provided security for the 2 million out of the 3 million by way of an undated security check issued in favor of the seller, which was provided upon execution of the agreement. So it was actually a secured loan, and he had a check in his hand.
Right.
Now, as it happened, there's no complaint about any of this because my client has paid this in full and actually paid it in good time on an advanced basis because of the targets that were reached on a combined basis. Okay.
When it says here, gross revenue of the parties per year, what revenue was in contemplation then that the L.l.c would be generating, having given over all of its sales team?
That's why it's important to focus on the word generate. Okay. If you remember the definition of gross revenue.
Yes.
And it's important to remember that it's not gross profit. It's not talking about profit after expenses. It's revenue. The total amount of money is generated. Okay. Now just pausing with that idea of generating in your mind. But can you look, please, again at clause? Well, we haven't looked at all of clause 5, but to answer that, look at clause 5 at page 35 using the red numbers.
45 for me, yes.
45. So clause 5.1a.
Yes.
The seller will lead and support the buyer in digital marketing with a focus on website traffic and lead generation. And there's reference to generation also in B. But most critically, if you look at clause 5M at page 48,
which you've already taken to me to, yes.
So I apologize for going back to it, but the seller will provide a detailed reporting on a quarterly basis, including the website traffic evolution, traffic sources per channel, number of leads per channel, both online and offline, cost per lead and channel, and also transactions and revenues generated from each channel. During the first 6 months of the partnership, the reporting will be bi-monthly. Which is why we've got this page open. If you look at clause 5.2, for the avoidance of doubt, the partnership is distinct from the business, and their respective considerations will accordingly be payable as per this agreement. Now, in a sort of a layman's attempt to explain this, but we've seen that spreadsheet where there's been attribution of leads to Lux Habitat's work product. Sotheby's is contemplating that the marketing consultant it's paying at least 2 million dirhams a year to will add some value in the form of not only providing marketing and website services, but also identifying for it what leads have been generated from that activity and what revenue has been generated from that activity. And that is going to be revenue of the seller. The seller still exists. It doesn't have sales agents, but it's moved into the modern new world of the internet. It's generating revenue through its internet channels. And it has the obligation of identifying which ones are which.
Right, so go back to the payment clause then, but I was asking you about 5.
So when we go back to, well, first of all, when we go back to 4, and so 4.1C, 1, 2, and 3.
Yes.
At that point, it's saying, for the purpose of the seller note, we're going to aggregate the gross revenue of both parties to work out whether the targets have been met. And I explained, though, at 5.2, for the avoidance of any doubt, that whole seller note situation is distinct from the marketing service arrangements. So if we go back to the marketing service arrangements,
this is clause 5 now.
Clause 5, so page 45.
I've taken the point. This is entirely distinct, and
it's entirely distinct because if you look at the payment methodology at clauses 5H and I, in clause 5H, the provision was that the buyer will pay in the first year a consideration of 2 million dirham to the seller for the branding and marketing services rendered to commence on the closing date, as in clause 5.1.j. Partnership fees will cover the cost that technology and marketing team required by the seller to render the service of the business and excludes any advertising costs such as property portals, any other marketing campaign or event. That's year one. And year one, therefore, is 2020 to 2021.
Yes.
After the first year, the annual partnership fees will be the highest of 2 million dirham, adjusted by the UAE price index, or 5% of the combined gross revenue of the previous calendar year. For the avoidance of doubt, if the combined gross revenue exceeds 40 million dirham, then the annual partnership fees will be determined by applying 5% of the combined gross revenue. And just pausing there, that does not say, in clear distinction to clause 4, combined gross revenue of the parties. So you say, well, what's it talking about? It's a defined term, gross revenue. Let's go back to the defined term. Gross revenue is the total amount of monies generated per year by the seller. Why is it using the word combined? Because that will be combined with any other affiliated companies, subsidiaries, or employees of the seller, i.e., the seller's residual marketing team or the seller's agents. Now, that, in a sense, is a complete answer to the case, but there are many more important points to note. My client actually paid in full the amount payable each year by respect to the $2 million figure, subject to the amendment I'll come on to show you. And you'll say, well, when was it meant to make payments and in what amount? You look at clause 5.1J. So this is page 47 at the top. The partnership fees, as per the above, will be paid by the buyer in advance on a monthly basis via a bank transfer to the seller during the first 5 working days of every month. Partnership should only become activated once the first payment has been received by the seller. So it's paying monthly the figure in advance.
So 1/12 of the figure.
What exactly? 1/12 of the figure in advance. Now, you would think what that would also result in is if in any given month a payment was made which was lower than it should have been, the recipient would have complained contemporaneously and triggered, if necessary, the protocol for resolving that payment dispute. Now, can I just then sort of take you through some of the other provisions before I come back to the amendment agreement? You'll see that clause 5.1K introduced the concept of the key performance indicators, whereby the performance of the partnership and the automatic renewal after the first 5 years will be subject to the following KPI measures.
Yes.
And K2 provided that one of those would be that the online direct channels should be the first lead generation source of the business during the 5th year. The methodology to measure it will be agreed between the parties once a complete online and offline lead tracking system has been implemented. Then L, if the KPI is not met, the buyer decides to terminate the partnership after the 5th year, there will be no marketing branding support given by the seller henceforth, but there are provisions entitling us to buy the domain name, for example. We then have looked at M, the seller's obligation, and 5.2. Now, clause 6 is worth looking at, default of payment. In the event the buyer fails to pay any due payments regarding the partnership or consideration as stipulated in this agreement, the seller will have the right to terminate the partnership and or this agreement if the conflict is not resolved as per clause 19.1 and 19.2 of this agreement. which would lead to termination of providing branding and marketing services, the buyer is mentioned herein, including but not limited to paying the balance amount of the seller note, disconnecting the website, withdrawing all such rights given to the buyer by the seller, as per this agreement, with no liability whatsoever on the seller. And all additional due accrued payments must accordingly be cleared to the seller within 30 days from the date of the termination notice. Quite a few points flow from this. One, the theme that they had to invoke the dispute resolution mechanism if there was a complaint about non-payment of a due sum. Secondly, it's clear that time is not of the essence for payment, certainly not by the buyer to the seller for the marketing support services, unless and until it becomes of the essence following that dispute resolution procedure and termination.
Sorry, just let me find that again. When does it become of the essence? After?
Well, it doesn't use the words here, but the point I'm making is that the seller, the marketing service provider, if it wasn't paid the full amount in any given month, it would have to invoke the conflict resolution provisions, which requires a 14-day notice of a grievance, followed by the prompt mediation facility, before it then has the right to withhold or terminate services. The logic of that is that payment, the time for payment, brackets, the amount of payment, is not of the essence or critical to the functioning of this agreement in circumstances where there is in any event a monthly fee being paid on a monthly basis. And all of those points, I mean, I know it may seem a bit scattergun or disorganized, but all of those points are not consistent with the notion that my client had an obligation to account immediately or on a monthly basis for the combined gross revenues of its business with a view to uplifting the payment on a monthly basis or by any given deadline. Now, just to illustrate that point by reference to the amendment agreement that I was trying to ask your lordship to focus on, perhaps in the abstract, if we just jump now to page 70, the amendment agreement.
Sorry, just let me get that. Is that 70 or 80?
Sorry, it's read 60, but page 70 in the bundle.
Yes, I'm there.
There are a couple of points to note about this amendment. Despite the parties' opportunity to revisit the terms of the original agreement, nobody identified or suggested that the original agreement required rectification or that there was a mistake in the definition of gross revenue. Nobody did that. Instead, they entered into an amendment agreement triggered essentially by Mr. Font demanding more money. And this provides for an adjustment looking forwards into 2021 and 2022. Clause 1, the annual partnerships go up, that the fees go up to a minimum of 3 million dirham, or 5% of the combined gross revenue of the previous calendar year. Once again, it doesn't say the combined gross revenue of the parties, in contradistinction to clause 4 of the original agreement.
So we have to look back to the definition again.
The definition of gross revenue. And then clause 2, that is then dropping the amount from 2022 onwards to the highest of 2.4 million.
Just pause a moment while I make a quick note, please. Yes, sorry. Go. You said go to clause 4.
Well, clause 3. So we've got clause 2 that drops it for that 2022 year. And then 3 provides that during the month of August 2022, at the end of every partnership anniversary, both parties will meet to discuss the performance of the partnership and the website in particular, and will review the partnership fees moving forward subject to market conditions, business forecast, and sellers' performance and obligations. Any changes in the partnership fees from September 2022 is subject to mutual discussion and agreement between the buyer and the seller. Unless there's a new agreement between both parties, the partnership fees described above in point 2 would apply. And just pausing there, this is, I think, part of what impressed Mr. Justice French. You just look at this and you ask yourself, what's actually happening here? My client is the client who's using a website provider who's subject to KPIs and performance indicators, whose job it is to generate leads and revenue through that channel, and then to identify what in fact it's done as sort of reward on its own performance, to then get to the point of triggering an uplift on its fixed fees by reference to its own performance. It's a complete commercial absurdity, we'd say, and this is supported by the client's evidence, to suggest that they would get paid come what may by reference to all of our activity on a gross revenue basis by reference to us. That somehow we'd buy their business, but they would sit there, and even if they were not themselves justifying themselves economically or commercially, would attract a profit share out of our revenue. They're not a shareholder of the company. They're not a partner under the general partnership. They're a service provider. So that is why in 3, there is a provision put in place to meet and discuss performance, and particularly the seller's performance and the seller's obligations. Now, you then look at clause 4, which we looked at already. As defined in the original agreement, the partnership fees will be paid by the buyer in advance on a monthly basis via a bank transfer to the seller during the first 5 working days of every month. From the 1st of September 2021 to the 31st of August 2022, the monthly payment will be 250,000 dirham. And from the 1st of September 2022, the monthly payment will be 200,000 dirham unless agreed otherwise. Now, those sums were paid. They were paid until the dispute involving Mr. Justice French, and actually what happened in court there was my client wanted security for the cross undertaking, and my learned friend said we could exercise self-help by holding back these payments as security for the cross undertaking from the point of the commencement of the injunction proceedings. So there's a short period of holdback during the litigation leading up to the termination, at which point we said, we're done with you because you've been behaving unreasonably in breach of your own contractual obligations, and you repudiated the contract. But those have always been paid.
So did you eventually did you hold on to these payments as security for the undertaking, and then not pay them? What happened?
I haven't got the precise date, but I think in about August 2023, there may be reference to 1st of July or some date post-dating the commencement of the litigation against us. My clients turned off the tap for those 1 or 2 months of payments, but they did so in circumstances where, upon delivery of the judgment, and at a time where there was still a contingent cost liability as well as a contingent liability on the cross undertaking, bearing in mind that we had to suspend our rebranding exercise for a period of 2 or 3 months while that all got sorted out, we then terminated the contract. And upon terminating the contract, no further payments have been made, but we submit on any proper analysis that's perfectly justified, because by then there'd been repudiatory breach as well as the establishment of contingent cross liabilities. And it was fully transparent. It wasn't a situation of us deceiving anybody about that. We made quite clear we're just not paying you anymore because of what's going on. But the point is, up until we got sued, we were complying to the letter with the agreed obligation. Now, as it happens, if you look at clause 5, the obligation that was then being taken on by the seller was to design and develop a mobile-first website to increase website traffic and lead generation. So in exchange for a higher fee, they were going to be doing more work to generate more leads.
This is an app. Is this an app essentially? You're talking a mobile-first website?
Precisely, it's an app for your phone.
Yes,
analogous, which is going to make it much easier for potential buyers to go straight to this website to then click through to express an interest in the property. And so it provides that from 1 September 2021 to 31 August 2022, the seller will design and develop a mobile-first website that will enhance the user experience, website traffic, and lead generation as per the scope outlined and schedule of this amendment. The seller commits to design, develop, and deploy the mobile-first website within 1 year in accordance with the schedule outlined in this amendment. The seller will roll out a complete development and deployment plan not later than the 30th of October. 6. Time is of the essence to the performance of the seller's obligations under this amendment. The seller will deliver the new website as per the milestones outlined in Schedule 2 of this amendment before 31 September 2022. 7. The seller will appoint a team of design and development professionals as outlined in Schedule 3. 8. The seller will provide a detailed quarterly report on the website's design and development progress. And then in case the buyer is objectively not satisfied, there's a protocol in place to solve conflicts and discrepancies between the parties as described in Clause 19 of the original agreement. During the period from 1 September 2021 to 31st of August 2022, the buyer has the right to hold back the monthly difference in case he's not objectively satisfied with the progress of the new first mobile website design development. Such payments will be held back until the work has commenced back and dispute resolved in accordance with Clause 19. If the seller performs to perform the services within the timeframe prescribed in Schedule 1, the buyer will deduct 12% as penalty interest.
So the monthly difference, that 83333 figure, is a 12th of what figure?
That is the, well, if I try and calculate it, I think that's the difference and the uplift that was being agreed to. It's a million. So
it's a million, is it? It's the million uplift.
So in Clause 1, you see in Clause 1
yes,
that they went from the original 2 million to 3 million. But as a performance incentive there, the point being made is if we're not satisfied with your work product, we can hold back the million or the 83,000 a month. And over the page at the top, just above the signature fields, except as set forth in this amendment, the original agreement is unaffected and shall continue in full force and effect in accordance with its terms.
Yes.
Going back to the main agreement, please.
I'll take a break, Mr. Potts, in about, where are we? 11:52. I'll take a break for comfort's sake for everybody of about 15 minutes at a point convenient to you in your submissions.
Does your lordship have 5 more minutes just to finish the agreement? Or,
yes. Yeah, do finish the agreement. That would be convenient.
Okay. So can we go back, please, to clause 9 in the main agreement, which is at page red 40, but I suppose 50 of the bundle.
I have it.
So accounts 9.1, the seller is entitled to retain certain future income generated from the deals agreed as per Schedule 1. The buyer should give the seller such reasonable access to the records for inspection by representative of the seller during business hours as the seller may reasonably require, including the right to take copies, extracts, and reasonable advance notice. Buyers should be entitled to receive all revenue from all future deals unless specified otherwise. The seller agrees all deals are transacted by the seller's team post closing date will be transacted and accounted under the buyer's company until the time all sales agents are transferred. 9.5, all information shared between the parties should remain confidential at all times. Now, as it happens, we submit that we did in fact provide reasonable access to the records for inspection. Indeed, they were partly responsible for generating the records and had access to them, as Mr. Fontmante himself seems to acknowledge. But all of these clauses have to be read understanding there's a difference between the consideration payable under the seller note on the one hand versus the consideration payable under the marketing services agreement on the other hand. And this is making quite clear that the buyer should itself be entitled to receive all revenue from all future deals, i.e. that's not part of your incentivization plan. Clause 10 is a late payment penalty. So late payment supposedly triggered a penalty rate of 12%, but again, that's consistent with the point. It's not a time of the essence provision for termination purposes. And then clause 11 is confidentiality. So clause 11, each party shall at all times use its best endeavours to keep confidential any business information which it may acquire, and shall not use or disclose any such information except with the prior written consent of the parties disclose the business information, as may be required by law or by the rules of any recognised stock exchange or governmental or other regulatory body, when the party concerned shall, if practicable, supply a copy of the required disclosure to the disclosing party before it is disclosed, and incorporate any amendments or additions reasonably requested by the disclosing party. Where prior to its acquisition it was illegitimately obtained, it was already legitimately in the possession of the party receiving the information from the disclosing party, where after its acquisition it was received from a third party who had the right to disclose the same and wasn't under an obligation of confidentiality, or E, where it's come into the public domain otherwise than by the breach of this clause 11. 11.2, if a party is required to disclose business information in respect to the business to its affiliates or to its affiliates' employees, advisors, or consultants, or to its advisors and consultants, case may be, in order to perform its obligations under this agreement or any agreement referred to this agreement, that party may do so, provided it makes each such recipient aware of the obligation of confidentiality assumed by that party on this agreement, provided it uses all reasonable endeavours to ensure such recipient complies with its obligations as if it were a part of this agreement. 11.3, the deal terms and conditions shall remain confidential at all times, unless otherwise agreed in writing by the parties. 11.4, any communication about the deal and partnership to the market team or employees must be agreed in writing between the parties. Now, this is obviously important to our case about misuse of obligations of confidentiality, but with respect, nothing in that clause, for example, facilitates or permits the disclosure of confidential information to the world at large through the process of the court filing, because that is not required by law. It's certainly not required by law in circumstances where there's been no opportunity for us to comment on that prior to the litigation grenades being launched. And equally, there is nothing here that requires disclosure of any of this information, which is highly confidential in a competitive marketplace, to a third-party litigation funder. So just there's nothing in these clauses that permit that. So we've already looked at, I think, the balance of this document, including the protocol to resolve conflicts and the governing law and jurisdiction provision. There are some schedules that you should look at to see if
I've read Schedule 1 because obviously that relates to Clause 9 that we've just been looking at on accounts, and obviously Mr. Montague-Smith relies on this clause and the schedule.
Well, I think there's some reliance placed either in the evidence or in submissions to Clause 1 of Schedule 1, yes, where it's somehow suggested there's another mistake in the drafting there, which allegedly gives you the clue that there's a mistake in the drafting of gross revenue. We don't accept that because...
Do you accept there's a mistake in the drafting there?
No.
But were these projects you say were not the projects of the party that Mr. Montague-Smith says they were?
He says they are our projects.
Yes.
And that's consistent with the language of the clause. Because
I'll need to look at it again. I'm referring to Schedule 1.
Yes. So do
you want to deal with his point, or deal with it in reply?
I can deal with it in reply, perhaps more easily. But we submit that actually, properly understood, it is the buyer's transactions that are not going to be part of any gross revenue calculation for the purpose of the seller note calculation, and it doesn't assist the interpretation otherwise.
Well, I'll look at it again and listen to what Mr. Montague-Smith says about it, and then you can reply as necessary.
And then you've got the financial records provision, which you will have seen that while there was not, according to the claimant, the provision of annual audited accounts on a timely basis, there was a willingness to provide that information up until the point where we were sued and the contract.
Sorry, which clause are you referring to now?
If you were to look at, so page 60, Schedule 3.
I haven't printed that off. Just give me a second. Page 60. Yes, the warranties.
There are warranties.
Yes.
Now, there's a whole debate one could have about what is a warranty in terms of future activity. Is it actually an operative contractual obligation, or it's simply a warranty? But buried in here at 3.3 is a wording that says the buyer shall send to the seller the revenue statements during the first 5 days of every month, the previous month's financial accounting reports, until the existence of this agreement. And then there's information that's meant to be in that information. Now, we say that to the extent that is an obligation which we don't fully accept, given it's in this warranty section, that information was in fact being provided. And we can see that there was access to it through the Google spreadsheets. 3.4 is the complaint about annual audited accounts, where it's suggested that we were warranting that the buyer would provide the seller the annual audited accounts during the first 45 days of every financial year, be conducted by one of the top 4 firms in the UAE. And it's quite true that there was a belated request just before the commencement of litigation for the audits, and there was a indication that SIR would get that process running, but unfortunately it got overtaken by events, including the allegations of fraud and the commencement of litigation. And the fact is, there's been no trigger mechanism prior to all of that under the dispute resolution conflict protocol.
What was the purpose, do you say, objectively? What was the purpose of this, I'll say for present purposes, obligation, noting your challenge to that? What was the purpose of the defendant supplying the seller with its annual audited accounts?
Well, you've got the seller note provisions. The seller note provisions, which had to provide the earnout based on the combined gross revenue of both parties. But there's no reason to think that this obligation is linked to a review of the figures provided by the seller in terms of lead generation for the purpose of its performance fees on the side of the marketing services contract. Now, as it happens, if you were to look at the parties' conduct, we don't suggest you need to, but there were no demands for that contemporaneously with each of those initial few years. The demand has only surfaced for the purpose of this claim. Now, as it happens, at 3.5, in line with clause 9.2, which was the reasonable access to records clause, the seller should have access to the buyer's financial accounts when clarifications are needed. And the seller can even do its own due diligence in this regard. None of that in our threat submission takes matters any further forwards in trying to identify where there's been a breach of the obligation, or what the obligation actually was. As I say, no inference can probably be drawn about any of this, because the reason it's not being provided now is because we're in litigation and we know that this claimant has not even returned to us the confidential information that it promised it would do, and has misused our confidential information and indeed gone into the market in competition with other brokers. So unless and until we end up with a supervised disclosure process, the court can't draw any inferences about any of that. Now, I'm conscious of the time to break. Those are the key points, other than you'll see the checks exhibited, including the security check, which was then, I think, returned when the seller note was fully satisfied.
Right. Very well. Shall we break there then? till 12:20 in the UK. That will be 16:20 in Dubai. 15 minutes. How long do you think you'll be?
I would hope to rattle through the rest of my submissions in an hour, but I'm conscious your lordship may have questions on some of the points of law or the authorities.
Right. Well, it doesn't look as though we're going to start Mr. Montague-Smith today then.
I'm obviously in your hands if you want me to move more forwards.
No. I'm not. It was me who thought this might take 2 days. It looks as though I might be right about that, but it is because I anticipated having some questions, and you have been on the end of those questions. So it will take probably take us into tomorrow. So we'll adjourn now and resume as I've indicated, and you can continue not under any pressure to complete your submissions today. Thank you. All present and correct, I think. Would you like to continue, Mr. Potts?
Thank you. Yes. Now, my lord, I'm going to try and structure this by reference to my skeleton now.
Yes, I've got it open. Just let me put some other things to one side. Yes, I have it to hand.
Thank you. Okay, so what I'm going to try and do first is to deal with the points that we say are merits points. Is there a real prospect of success or a reasonable ground for bringing that bit of the claim or the claim? And then I'll come back to the abuse of process points. So with that in mind, page 16 of my skeleton, internal page 16.
Yeah, I've got a separate document, so internal pages and internal paragraphs are perfectly acceptable.
Our first heading is to the effect that there's just simply no proper basis to claim a breach of an obligation with respect to payments of gross revenue unless there's a properly pleaded case for rectification. And the real focus of this submission is that it is legally impossible on the authorities in our submission, when you actually read the agreement and the amendment agreement, to reach the conclusion that there is a manifest typographical mutual mistake in the definition of gross revenue. Now, just the authorities on that, I've cited them at the footnote 43, but if I can just show you a couple of passages. The first one that might be helpful is actually the Australian decision of Justice Goodman in Re ACN, and that starts in the bundle at page 3373. Oh, sorry, the passage that we're looking for is actually at, it starts at page 3371 of the bundle.
Is that 8-1 for me? Yes, probably.
I think it's 3371 at the bottom of the page. If we use the red numbers, 3371.
What's the paragraph you're?
So at the bottom, paragraph 18.
Yes, I have that. It is 3371. Yeah.
I don't want to trouble you with the facts of the case in the interest of time, but the principles relevant to the correction of obvious errors by the application of principles of construction were restated in Federal Commissioner of Taxation, and the summary is then set out. Correction of obvious errors by an application of the ordinary principles of construction is well known. Words may generally be supplied, omitted, or corrected in an instrument where it's clearly necessary in order to avoid absurdity or inconsistency. 35. The principle is premised on absurdity and not ambiguity. Indeed, it's applicable even where the language is unambiguous. 36. Turn to Leeming Justice of Appeal for the most recent expression of the principle, and then it's a citation to the case of Seymour White Constructions. At common law, if the error is clear, and it's also clear what a reasonable person would have understood the parties to have meant, then the mistake may be corrected as a matter of construction. This is old law. If we just jump down towards the bottom, 2 conditions are necessary in order to correct the contractual language in this manner. A, that the literal meaning of the contractual words is an absurdity, and B, that it's self-evident what the objective intention is to be taken to have been. And that then acknowledges at the top of 3373 that the position is consistent with that in the UK, citing Arnold and Britton and Pink Floyd music. The court must be satisfied both as to the mistake and the nature of the correction. Then the next passage on 3373, the court must be satisfied of those matters to a high level of conviction. To use the language of Chief Justice Dixon and Justice Fullegar, it must be clearly necessary in order to avoid absurdity or inconsistency. As this court said in Miwa and Siantan, the test of absurdity is not easily satisfied. Any question of absurdity or inconsistency must be identified according to established principles by reference to the text of the agreement as understood in its factual and legal context. Courts which are asked to delete, insert, or rewrite part of a contract because of what is said to be an obvious error should bear steadily in mind that imperfections and infelicities and ambiguities in contractual language commonly reflect the give and take of negotiations, or the parties' appreciation that some obscurities are incapable of resolution. As Lord Hoffman explained, the court does not readily accept that people have made mistakes in formal documents. I note the expression of the test involving two conditions must be satisfied, namely the literal meaning of the contractual words is an absurdity. It's self-evident what the objective intention is to be taken to have been. The level of satisfaction about these matters must be high. Now, that is, in a sense, consistent with the English legal position, which is summarized in various cases, one of which is Britvic P.L.c. And for that, I think if we look at page 3153, I hope, we'll find that case report at page 3153.
Yes.
And the passages that are relevant there are paragraphs 18 and 19, starting at page 3161.
Yes, I'm there.
And it goes through to paragraphs 29 to 33, which start at page 3164. And what I just wanted to draw to your attention at paragraph 29 is the following summary of the position. The approach indicated by Rainy Sky, Arnold and Britton, Wood and Capita, and Barnardo's is clear. In construing a pension scheme deed, one starts with the language used, identifies its possible meaning or meanings by reference to admissible context, adopting a unitary process to ascertain what a reasonable person with all the background knowledge reasonably available to parties at the time would have understood the parties to have meant. If, however, the parties have used unambiguous language, the court must apply it. And then, as it happens, the context of a pension scheme deed is antipathetic to a strained meaning to the words used. In this case, considerable weight must be accorded to the fact the drafter has used the unambiguous words or any other rate, which are not naturally mean or any higher rate. 31, this is not a case where there's been sloppy or unclear drafting. The words used by the skilled professionals involved are clear. I accept the factual matrix, the commercial consequences are not to be ignored in the necessary unitary exercise, even in such a case. But even giving these facts full weight, it seems to me the judge's interpretation can only properly be reached if it will be concluded that there had been a clear mistake on the face of the instrument and that it was clear, either from the instrument or admissible extraneous evidence, what correction ought to be made in order to cure the mistake. Now, perhaps that's all a statement of the obvious, but having shown your lordship the agreement and you've seen the unambiguous wording, the clear wording drafted by lawyers, according even to Mr. Fontmante, of a document that defines the concept of gross revenue for the purpose of Section 5 as being the gross revenue relating to fees or leads generated by the seller, we respectfully suggest it is unreal, unrealistic, unreasonable, effectively legally hopeless to try and present this claim on the basis that it is utterly clear that that clause is just simply a mistake. And it's particularly difficult to understand how that case can be properly advanced in circumstances where there was an amendment agreement entered into So an opportunity for the parties to revisit the wording of the definition, and they did not do so. And is it potentially inconsistent with commercial common sense? No, it's not, because the most obvious commercial analysis, which actually also, although not directly on point, but found favor with Mr. Justice French on the rebranding issue, is this is a professional service agreement where you have a principal and an agent, and the agent's fees are fixed at a certain level, subject to incentivization that might give it a bit of an upside if its own performance merits it. Now, that's a lot of paraphrase there, but your lordship would have to conclude that it is properly arguable that there is no possible scope for argument to the effect that this only means one thing, which is that the word seller actually means buyer. And we respectfully suggest that can't be reached in this case by the process of interpretation. And that is a point which won't improve at trial. It is what it is, essentially, based on the contract wording itself and the commercial context. Now, I fully accept, as we do in our written submissions, that if the claimant wants to argue that the contract doesn't mean what it says it does, he has to advance a claim for rectification. Now, rectification is in theory available under DIFC law, and that is set out, I think, in Article 41B2 of the Law of Contract. So if it's helpful just to bring that up, your lordship will find the contract law at page 3395.
Yes, I'm there. And the page of the article is?
It's Article 41B, brackets 2.
And it's on 33, which page number?
Sorry, just bear with me 1 second.
It's just it's quicker than scrolling is the only reason I'm asking for the number.
Hang on a second.
Don't worry, I'll scroll there.
Make sure I've got the right.
I've got it. I can just go to my highlight.
Trying to understand why I've now not found it, but
page 3546.
Thank you very much. 3546. Grateful. Okay, I'm so sorry. Actually, it's not the law of contract. It's the law of damages and remedies we should be looking at. I do apologize. So it's 41
to the page. I have it. Yes, thank you.
So it's Article 41B of the law of damages and remedies, not the law of contract. But under heading rectification, a court may order rectification of a contract to reflect the intended agreement of the parties if there has been a relevant common mistake or relevant unilateral mistake at the time the contract was formed. A relevant common mistake exists where the parties had a common intention, whether or not amounting to an agreement in respect of a particular matter in the contract. There was an outward expression of accord. The intention continued at the time of the execution of the contract, and by mistake, the contract did not reflect that common intention, and all parties made a mistake about the contract not reflecting such common intention. You'll then see, if you go down to page 3547, subparagraph 4, rectification may be refused if it would or might substantially prejudice a non-party to the contract, there has been unreasonable delay in pursuing the remedy, or it's otherwise inequitable to award rectification. Rectification of a contract has retrospective effect, such that rectification is effective from the time the contract was formed. Now, the difficulty, we would say, with the draft amended particulars that seek to now introduce this is that it doesn't address with proper particularity any of these core elements, and nor does it address how the concept of rectification of the primary agreement is meant to operate when there's been an amendment agreement, because one would have to focus on the common intention, for example, and the outward expression of accord, both at the time of execution of the primary agreement, but also at the time of the amendment. So we don't need to turn it up right now, but your lordship will have the draft amended particulars of claim, the paragraph that alleges rectification. And we say it's wholly inadequate from the point of view of particularization, and therefore should not be allowed, because actually it doesn't itself present a coherent cause of action for rectification.
It alleges common mistake. So we are in the territory of Article 41b(2). It's clear enough on that point, is it not? Paragraph 7.1, I think it is.
It alleges common intent. What is not clear, though, are the particulars that justify that allegation. What is being relied upon, in fact, to prove that there was a common intent? But more importantly, what is being alleged to justify the allegation that there was an outward expression of accord? What is relied upon to justify the allegation that the intention continued at the time of the execution of the contract, brackets, and at the time of the amendment of the contract? And what is being alleged to justify the allegation that the contract did not reflect the common intention and that all parties made a mistake?
What do you say would be an outward expression of accord, either generally or in the context of this case? And at what time is that outward expression required?
From a pleading point of view, this is relatively, we submit, straightforward. It's a little bit like pleading the terms of an oral agreement or an agreement by conduct. You simply need to identify who said what when to whom with sufficient particularity so that the draftsman of a defense can properly take instructions to come back and say, no, that wasn't said, or that wasn't properly to be inferred from somebody's conduct. It's not the task of a draftsman of a defense to wade through a party's witness statements to try and decipher what are the particulars that are being alleged to justify an allegation in a pleading of outward expression of accord. Now, I don't, for present purposes, accept that it would be sufficient to say, well, there was an email sent 3 months previously, and that was before COVID, but we still thought, that was the deal. Because you can see, actually, when you look at the contractual correspondence, that the deal transformed dramatically from when it was first talked about to what actually was signed in COVID times, in circumstances where really things were moving at lightning speed and there was no deal until there was a deal. Now, as it happens, I mean, you have some very difficult problems as a claimant asserting rectification when at the same time you've agreed an entire agreement clause. It's not perhaps conceptually impossible, but it's a pretty strong barrier to the notion that you try and find an outward expression of accord in some pre-contractual discussion in circumstances where two corporate entities who both need corporate approval to sign off on a contract have agreed to an entire agreement clause. It's the same reason why the variation provisions normally say no variation except in writing. It's just inherently unlikely that people will be agreeing to one thing when they're negotiating as contracting entities, corporate entities. But
could it not be a post-contractual outward expression of accord by conduct? So that, for example, if there were payments in accordance with gross revenue as per the claimant's definition of it and meaning of it, by reference to the buyer's revenue, would that not be an outward expression of accord as to the meaning of the agreement?
No, I submit it's not as a matter of law. Any post-contractual subjective statement or act or behavior, none of that reflects what is necessary, which is the outward expression of accord prior to execution of the written document, so that you can say there's a clear mistake capable of rectification. Now,
under DIFC law, though, I am entitled to take account, a court is entitled to take account of post-contractual conduct, is it not? Just remind me of that.
Can we just look at that? I think that is in the contract
law.
That
is in the contract law, yes. And I have highlighted that.
No doubt Mr. Montague Smith can help me out because it's a little jump back there.
I think I'm there. Yeah, interpretation. It's page 3407.
The
Yes, there it is. C, 51C, the conduct of the parties subsequent to the conclusion of the contract.
But the tension, which we suggest only admits of one answer, is that it's one thing to be interpreting an existing contract. The exercise of interpretation under DIFC law does have this unusual set of provisions which are alien to the English lawyer, to the effect that you can look at conduct, but that's for the purpose of interpretation. Now, in our case, we submit that you have to have regard to the entire agreement clause that essentially excludes both pre-contractual and post-contractual conduct. By agreement, it's not admissible. But in any event, that is not relevant to the question of rectification. No court would ever say that a contract should be rectified retrospectively by reference to one party's subjective conduct afterwards. Now, here that there are some.
It's not what the point is. It's not one party's. It's both parties' conduct. If one is paying and one is receiving, and or one party is claiming at the time by rendering an invoice, you've shown me the invoice, that an amount is due on its understanding of the contract, and the other party pays on the basis of that understanding. That's a common understanding. Is that not relevant to the outward accord, a sign of accord?
Well, no, there are different ways of trying to answer it. But for example, an invoice might be sent to the accounts department. The accounts department might pay the invoice without analysing what was in the mind of the authorised person on behalf of the company to enter into the contract. So you can see the practical difficulties that immediately emerge if what you're looking at is what does the back office dealing with an invoice thinking or doing, versus what do you have to establish is in the mind of the relevant contracting party at precisely the moment they're signing the written agreement, and are therefore alleged to have made an error, a common error, which you can clearly establish by reference to the outward expression of accord. So, I mean, obviously, the examples of this, for example, let's say in an insurance contract situation, is where the insurance broker writes to the underwriter and they both write to each other simultaneously to say, yes, you are insured for flood risk. But then they publish the insurance policy, and on the same day they're saying you're insured for flood risk, cover bound. There's then an insurance policy that excludes flood risk. And there the court would have no difficulty saying, well, there's a simultaneous outward expression of accord that predates or is simultaneous with the contract. You can see there's a clear mistake requiring rectification. But in my submission, because this is perhaps the area that I can't produce appellate authority directly on point, but in my submission, the correct approach would be to say that post-contractual material, albeit under DIFC law, in the absence of an entire agreement clause, might be one of various factors that the court takes into account in the iterative process of the interpretation of a contract. It would not be for the purpose of rectification. Now, this case is, of course, nuanced because you've got a primary agreement and you have an amendment agreement. And so the amendment agreement takes effect from its date in accordance with its terms. And so one would actually need to understand whether it's being alleged that as at the date of the amendment agreement, there continued to be this alleged mistake and there continued to be an outward expression of accord. So in that sense...
And there is in the amendment agreement that last clause, which is a reiteration, if you like, of the continued force of the first agreement, the original agreement.
Precisely. But you need to interpret the two together. And we would say that when you actually look at the clauses I've shown your lordship, you can see that the notion there's just been a scrivener's error or a genuine mistake with respect to the definition of gross revenue is profoundly undermined by the amendment agreement. Now, that's not a question of me saying I'm relying on post-contractual communications impermissibly. I'm pointing to the actual agreement to illustrate why it's not possible. But all of this, if I may say so, it illustrates why the casual approach on the part of the claimant to introducing this amendment under pressure at the very last minute before the last hearing, begrudgingly and reluctantly, effectively, it's not a proper pleading of rectification. And no court properly should say, well, I'll just give you blanket permission to amend and fill in the gaps later on. The court should say, I need to see your actual pleading, properly particularized, supported by credible evidence, before you've satisfied the burden of getting permission to amend. This is not a question of me. This is why we go back to the debate about whose burden is it. I'm not actually currently striking out a paragraph that's been pleaded. I'm explaining to your lordship, if I can try to do so, which is that the current draft amendment is not good enough to plead out rectification. I think your lordship has my point on that.
Yes, I do. Sorry, these are very interesting points. We're operating under DIFC contract law and the law of damages and remedies. And certainly the contract law is very different to English contract law, with which we're also familiar. So we have to, as it were, pull up our bootstraps and think again at every point.
Sure, I don't want to approach matters in a lazy or shortcut fashion, but there is a school of thought that whether it's New York commercial law, DIFC commercial law, or English law, all roads lead to Rome in a sense in a commercial dispute. I mean, we do have a written contract here, and the court must, if anything else, give a degree of primacy to that document rather than scrambling through the weeds of he said, she said. The next point that I wanted to touch on, going back to the points I want to cover orally to supplement the skeleton, is if we move on to the question of fiduciary duties. This is dealt with in my skeleton at internal pages 17 to 19. The core point really here is that found in Article 1581 of the Law of Obligations. So if I can show you that, please, and that will come up at page, just about to get that. So it's page 3618.
Yes.
The Law of Obligations has a section Part 8, fiduciary duties. This part applies to any person who, in relation to another person, his principal is a fiduciary. The part doesn't apply to relationships arising under agency. 1581, the person is the fiduciary of another if he has undertaken, whether or not under contract, to act for or on behalf of another in a matter in circumstances which give rise to a relationship of trust and confidence. The point there is you will have a principal to whom a fiduciary has undertaken to act for them or on behalf of them in a matter giving rise to a relationship of trust and confidence. 1582.
So sorry, just then address 7.2.4 of the original particular claim, page 1637.
7.2.4.
This is, if I do it a disservice, it seems to be the main point of Mr. Montague Smith's contention that there is or that the court may find there is a realistic case, a real prospect of the court accepting that there's a fiduciary duty. This is to the fore, I think, 7.2.4. He'll correct me if I'm wrong, but I want to give you the opportunity to deal with it.
Yes, his case is that although he was the service provider, his client, and although they're meant to provide services subject to key performance indices and our obligation is simply to pay them, somehow we owe them a fiduciary duty, not just a contractual duty, but a fiduciary duty, which at the end of the day is a duty of loyalty a duty of good faith. We owe them a fiduciary duty with respect to what? The payment of gross revenues, or generally we're the fiduciary and they're the principal. It doesn't make any coherent sense, this suggestion. There are many cases where parties have, for example, reciprocal obligations, or one obligation owed to one party and the other. You could have even obligations of good faith and fair dealing in a commercial contract, but it doesn't follow that you're a fiduciary for the other person. Now, I'll show you the authorities in a moment, but if we can just go back to the legislation, the 1582 provides a presumption. It's presumed, unless demonstrated to the contrary, that persons acting in the following capacities are fiduciaries: an attorney to his clients, an employee as to his employer, director of a company as to the company, a partner of a partnership as to the other partners, a member of an LLP as the LLP, receiver of a company as the company, and a trustee as the beneficiaries of the trust. Now we're not in any of those presumed relationships. It's common ground that this is not a partnership, whatever the word was attributed to it on the face of the document. In all other situations, it's a question of fact, whether in all the circumstances of the case, a person is a fiduciary. Now here, even on the face of the contract, it's impossible to see how on earth my client could become a fiduciary to L.l.c. The reason you can see that is because if you look at 1591, fiduciary duties, one, a fiduciary acting in his capacity as such is under an obligation of loyalty to his principal. Two, a fiduciary obligation of loyalty comprises such the duty set out in Schedule 3 as are appropriate in all the circumstances of the relationship between fiduciary and his principal. Three, a fiduciary may exclude a restricted obligation of loyalty under this article by contract with his principal, subject to the implied terms in contracts. Now, none of this marketing service relationship conceivably points in the direction that Sotheby's International Realty has an obligation of loyalty to L.l.c. What it has is its contractual rights and remedies leading up to the point where the contract was terminated. Now, to illustrate the case law on fiduciaries, and there's obviously a lot of it, the judgment I just wanted to draw your attention to is the decision of the DIFC Court of Appeal in Gate, Mina, and Tabarak. And if we can jump, please, to page 3255 of the bundle. Oh, sorry, 3254. Can I invite you to look at paragraph 239 of the Court of Appeal judgment? It references submissions and citation of a case called Al-Nehayan, which was a judgment of Mr. Justice Leggett, I think, as he then was. And the passage in Al-Nehayan at 157 cites that it is exceptional for fiduciary duties to arise other than in certain settled categories of relationship. The paradigm case for fiduciary relationships, of course, that between a trustee and the beneficiary of trust. Other settled categories include partners, company directors, solicitors, and agents. Over the page at 3255, paragraph 240, DIFC law defines fiduciary relationships in very similar terms. It's a reference to Article 1581 and Article 159, and then there's a further reference in paragraph 240 to that Schedule 3. So the duty under Article 159 is explained in Schedule 3 to include acting in good faith in the interest of the principal without regard to the fiduciary's own interest, avoiding conflicts of interest, not making a secret profit, confidentiality, and the duty to exercise reasonable care, skill, and diligence. Now, this case is not directly on point, but you can see it imports effectively English law as being persuasive in the analysis under DIFC law. The next case I wanted to show you, if I may, is the one that we see at page 3291. And it's a first instance judgment of Mr. Simon Burt as a deputy judge of the High Court. But the paragraph that may be helpful to look at, just to summarize the legal principle here, is at page 3335.
Is that the red number or?
Sorry, the red number 3335. Can you see that there's
what paragraph number?
paragraph 179? There's
Yes.
a reference to three authorities, the first being Lord Justice Millett in Bristol and West Building Society,
Yeah.
which replicates really the wording, or has been replicated in the DIFC law. Then there's a reference to Glenn and Watson, in which Justice Newgee summarized the principle applicable when identifying whether fiduciary duty is owed. And then in 180, there's citation of Glenn in further detail. Can I just ask you to look at that? 1311, there are a number of settled categories of fiduciary relationship. 2, outside these settled categories, fiduciary duties may be held to arise if the particular facts warranted. Identifying the circumstances that justify the imposition of fiduciary duties have been said to be difficult because the courts have consistently declined to provide a definition or a uniform description of a fiduciary relationship. Slightly different in the DIFC, of course. 3, over the page, fiduciary duties will not be too readily imported into purely commercial relationships. That does not mean that fiduciary duties do not arise in commercial settings. Indeed, they very frequently do, as the example of agency illustrates. But outside the settled categories, this is not common, it being normally inappropriate to expect a commercial party to subordinate its own interests to those of another commercial party. 4, a joint venture is not one of the settled categories of relationship giving rise to fiduciary duties between joint venturers. Although at first sight the analogy with a partnership might suggest it would be, it's clearly established the phrase joint venture is not a term of art in business or in legal context. Each relationship which is described as a joint venture has to be examined on its own facts and terms to see whether it carries any obligation of a fiduciary nature. 5, the default position is that no such fiduciary duties arise. In the absence of agency or partnership, would require particular and special features for such fiduciary duties to arise between commercial co-venturers. Examples of cases where exceptionally fiduciary duties have been held to arise are the decision in Ross River, Weatherspoon, in which one director, the defendant, was found to have owed a fiduciary duty, but the other two not. And it was said to be a good illustration of the proposition existence of fiduciary duty is fact sensitive. But with these can be contrasted two cases in which fiduciary duties have been held not to arise between co-venturers. And then there's a discussion of various factors. And I don't want to read through all those, but you can look, please, at page 3338 at subparagraph 7. Without in any way attempting to define the circumstances, it seems to me that what all the citations have in common is the idea that A will be held to owe fiduciary duties to B if B is reliant on, dependent on A to exercise rights or powers, or otherwise act for the benefit of B in circumstances where B can reasonably expect A to put B's interests first. That may be because B has himself put his affairs in the hands of A, or maybe because A has been agreed or has been appointed to act for B's benefit. In each case, the nature of the relationship is that B can expect A, in colloquial language, to be on his side. That is why the distinguishing obligation of fiduciary is the obligation of loyalty, the principle being entitled to the single-minded loyalty of his fiduciary. Someone who's agreed to act in the interest of another has to put the interest of that other first. That means he mustn't make use of his position to benefit himself or anyone else without B's informed consent. 8, this analysis also explains why fiduciary duties will not readily be found in commercial settings. In commercial dealings, the relationships are usually primarily contractual, and it is of the essence of commercial contracts that each party is usually entitled, subject to the express and implied constraints of the contract, to seek to prefer his own interests, and is not obliged to put the interests of the party first. So far as joint ventures are concerned, fiduciary duties may in particular be found to arise where one party has control of assets, which are to be exploited for the joint benefit of both. And then you'll see the final paragraph 10 in that context. Now, we would say that we've no difficulty with a case for breach of contract that identifies alleged contractual obligations. It is unsustainable as a matter of law to argue in this case that the obligation to pay revenues or to pay professional fees to a marketing agent is a fiduciary duty, or that there is a fiduciary duty with respect to the provision of information. That's a contractual obligation, not a fiduciary one. And you can see the difficulty with that, because I've already shown you the contractual provision 51M, in which L.l.c was obliged to provide reports and information to SIR. It obviously did have its own set of fiduciary obligations because it was an agent. It was our agent. We were paying it on an exclusive basis, essentially, to manage our website. It was our fiduciary. It's inconceivable to understand how the agent can then turn around and say to the principal, sorry, you're my fiduciary. That would be inconsistent, because then they'd both be having to act fully in each other's interests rather than their own. So it is, as we say in our submission, unsupported by the law and the contract wording, and it's actually unsustainable as a matter of logic. It's self-contradictory.
I'm not, for the present, disputing what you've just submitted. I will consider it and weigh it. But is there any authority which specifically says, or specifically holds, I should say, where it was contended that contracting parties owed reciprocal fiduciary duties, that proposition was rejected? Is there any authority you're aware of that holds that? I can see your argument that it is impossible, for how could one, as it were, put the other first, as in short, he is obliged to do if he has a fiduciary duty. Is there any authority you're aware of or can show me where this has actually arisen before?
I'm not sure I can do that, but I just want to, it may assist if I show you paragraph 191 of the judgment we're just looking at 3341.
Go back there.
So page 3341, paragraph 191.
Yes. Oh, I've highlighted that. You must have drawn that to my attention in the skeleton.
Right. So what, the reason I highlight that is because you can have many cases, including contractual cases, such as employment contracts, which attract an implied obligation of trust and confidence. But the mere fact that there's an implied contractual obligation of trust and confidence does not mean that it's a fiduciary relationship. And that's the point being made here. Parties can trust each other without there being fiduciary relationships, and contracting counterparties are often one example. What is meant is that one party places himself in the position where he trusts and provides that the other party will act exclusively in the first party's interests. Now, that is perfectly straightforward in every case. You could have a slight debate in a genuine partnership context, where there may be a debate about whether each partner is simultaneously owed and owes fiduciary obligations. But that is sui generis, because the partnership is not itself a legal entity, but really what is happening there is that each partner owes the fiduciary obligations to the partnership as a whole, not to any one individual partner. But again, that now one can take limited comfort from authorities on different facts at the best of times. I'm not aware of any professional services agreement, and I'm not sure my learned friend can point to one, but I'll be interested to see if he can, which even hints at the possibility that a professional service provider, a marketing service provider, a real estate agent can be owed fiduciary obligations by the principal. That is not in the recognized class, and it would be counterintuitive given the provisions of the contract and the mechanics of the contract. And there will be many cases, where one party has a duty to cooperate or provide information. It's never suggested that the information obligation is fiduciary in nature. Each party is entitled to act in its own interests. So we respectfully suggest that this whole fiduciary argument is a non-starter. And if you were to strip that away from the pleading, but leave the balance of it, it would be important because it would be a critical step in the claimant's analysis in support of the claim, for example, of Article 40 damages. They say you're a fiduciary and it's therefore particularly egregious that you've acted in breach of your obligations. We say, no, this is just a contract, just a commercial contract. If every time there's a commercial contract in Dubai, somebody claims aggravated damages, they'll be saying it about every breach of contract. Every court case will become impossible to litigate because the court won't be asking itself, has there been an objective breach of contract? The court will be asking itself a whole lot of satellite questions about people's state of mind, whether they thought they were fiduciaries, whether they're acting in their own self-interest, all of which is anathema to the concept of efficient breach. Contractual relations are premised on the notion that a party, at the end of the day, is entitled to breach a contract subject only to compensatory damages. So the fiduciary limb, we would say, has been put in there to bolster that bit of the claim when it's unsustainable. Can I move then to the next point in haste, which is the complaint that another company called Prime Realty is alleged to have been an affiliated company. This is dealt with in my skeleton at pages 19 to 20. I don't need to spend very much time on this because, of course, our primary position is we don't even get into this territory if we're right about the meaning of gross revenue being the gross revenue of the seller. But without prejudice to that, in the alternative, we submit it's inconceivable to understand how Prime can be properly alleged to be an affiliated company of SIR. Now, it's worth noting that Mr. Fontmante has introduced a ream of additional evidence in his witness statement to try and make good this proposition, none of which is actually pleaded. So the focus really should be on the pleading. But we would respectfully suggest when you actually read the clause in context and you look at the definition of subsidiary and you consider what is an employee and what would ordinarily be an affiliate, the mere fact, it's a coincidental fact analytically, that company A may have common ownership on the part of one or two individuals as company B does not mean that they are affiliated companies. And equally, the fact that they are in some sort of other relationship does not give rise to an affiliate for the purpose of essentially company law. Now, obviously infelicitous that affiliate is not expressly defined, but if it's helpful, the regulatory law does have its own definition of affiliate, which in turn is defined by reference to group companies and parent companies and subsidiary companies. But there's no suggestion in that legislation that individual common ownership could conceivably give rise to the meaning of an affiliate for regulatory purposes. Not sure Your Lordship needs to see that, but it's in the regulatory law at page 3524 of the bundle.
I looked at it. You needn't trouble.
Okay.
Yeah.
As I say, this is probably, if we're correct on the balance of our submissions, an academic point, but it's thrown there highly prejudicially to somehow suggest that there's been a contrived attempt to asset strip the company somehow, or a contrived attempt to deliberately avoid obligations. All of that's very hard to follow, given what we say is the correct meaning of the contract in the first place.
Well, the allegation is diversion of revenue, so that it's not within their definition of gross revenue.
Right, which assumes, as I say, that seller means buyer. But
yes.
But the only other point I would also invite Your Lordship to note is that my client, which trades as Sotheby's, is of course in an affiliation with the international Sotheby's brand. And if the other side were correct in their analysis of what affiliate means, it can be as broad as a degree of connectivity or a degree of overlap. The logic of their case would result in the absurd proposition that somehow my client, if gross revenue is gross revenue of the seller or any affiliates or any subsidiaries or any employees, it would conceivably have to account for the global revenue of Sotheby's on the basis of that alleged affiliation. And the same could be said if the owners happen to own a window cleaning shop or a dry cleaners down the road. It clearly needs to be read in the context of the triumvirate of alternatives, which are subsidiaries, affiliates, or employees. To give that meaning, the ordinary meaning would be an affiliate being a company within the same corporate group, i.e. the same parent. So moving on to my next point, because I need to rush through this. Can I then move in my skeleton to the fourth ground of argument, which is that we say there really is no basis for alleging unlawful termination by my client. Can I just...
You've dealt with this quite substantially already, haven't you?
I have. The only point I just wanted to make sure you had was to understand that even though the contract has its own termination mechanics to do with the lock-in period of 5 years and then the renewal or the 10-year period, it's well established matter of law that those termination provisions do not displace the ordinary rights under legislation or at common law to terminate a contract. And in support of that, we've cited the provisions of the contract law in the DIFC, and particularly, I think, Article 86, as well as Article 77 to 88.
Do you want me to look at those now? I will. I just want to refresh my memory.
It's essentially, if you look at, for example, Article 86, which is at page 3415.
Yes, I'm there.
Article 86 provides that a party may terminate a contract where the failure of the other party to perform an obligation of the contract amounts to fundamental non-performance. In determining whether a failure to perform an obligation amounts to fundamental non-performance, regard should be had in particular to whether non-performance deprives the aggrieved party of what it was entitled to expect, strict compliance with the obligation which has not been performed is of essence under the contract, non-performance is intentional or reckless, non-performance gives the aggrieved party reason to believe that it cannot rely on the other party's future performance. In the case of delay, aggrieved party may also terminate the contract the other party fails to perform. Notice of termination, the right of a party to terminate the contract is exercised by notice to the other party. If performance has been offered late or otherwise doesn't conform to the contract, the aggrieved party will lose its right to terminate the contract unless it gives notice to the other party within a reasonable time after it has or ought to become aware of the non-conforming performance. Anticipatory non-performance, where prior to the date of performance, one of the parties is clear there'll be fundamental non-performance, the other party may terminate the contract. Effects of termination. Termination releases both parties from their obligation to effect and to receive future performance, doesn't preclude a claim for damages for non-performance, and doesn't perfect provisions for settlement of disputes or post-termination non-severable clauses. So when you look at all that, and again, look at what has actually happened here, as a matter of fact, it's quite clear that we have validly terminated the contract by the notice of termination. There has never been any real or genuine attempt by Mr. Fontmante to terminate the contract on notice, except through his particulars of claim, purportedly. And it's very difficult to see how it can be possibly argued that we've unlawfully terminated this contract. As I said, I'll be repeating myself to go through all the background, but we clearly have that right to terminate in any one of those circumstances. The most important one of which you might just simply say is, did we have reason to believe that we could not rely on Mr. Fontmante's future performance? And clearly, the fact he's suing us and alleging fraud, deceit, dishonesty against his own principles, and has refused to go down the path of implementing the branding strategy, means that we had reason to believe we couldn't rely on his future performance. So that it is, in my submission, a very difficult pleading for my learned friend to justify. The next point in the submissions, pages 22 to 23, essentially repeats points I've made already orally about the inflation of the claim value and the lack of particularity, as well as the failure to give real credit or to disclose alternative income threads. The final point, which obviously is interesting given its difference between DIFC law and other jurisdictions, relates to the law of damages. And the key points I just want to highlight on this, which I've not really mentioned, is that there really is something quite exceptional about the allegation that we have deliberately and dishonestly acted in breach of an agreement in circumstances where the claimant himself has already established once before a judge that he didn't understand other bits of the agreement and that his view of them were utterly uncommercial and unsustainable on the language of the document. And in circumstances where the claimant himself is now seeking permission to rectify the contract on the basis it's got a profound mistake in it, it's very hard to see how it can be plausibly alleged that there's been a deliberate and dishonest breach or that there's been some egregious conduct. Now, so far as contract claims are concerned, I think your lordship has my point that although there is a first instance decision of the DIFC court that contemplated the possibility in extreme facts that such an award might be available in a regulatory case or a contractual case, this is clearly not such a case. And if you were to compare the position with other jurisdictions, as well as the structure of the DIFC laws on compensation being compensatory and not arbitrary or expropriative or punitive, breach of contract cases do not ordinarily attract aggravated or exemplary damages. And that's the position in the UK, in Australia, and even in the US jurisdictions that contemplate the award of exemplary damages for tort claims or for fraud, for example. And as I said, the most helpful, pithy summary on this is in Johnson and Gore Wood, which I've cited at paragraph 44 of my skeleton. It's the judgment of Lord Cook at page 49 of that judgment. I mean, contract breaking is an instant of commercial life, which players in the game should meet with mental fortitude. This is really the concept of efficient breach.
The language of the article, though, 42, is entirely without restriction, is it not? Remind me, let's look at that just again, please.
So what I would say is important is if you were to look at page 3535, just as a shorthand to the structure of the legislation, 3535 part 2, which is sections or articles 7 to 22, deal with damages under the law of contract.
Yeah.
And the point I would just draw to your attention is that under the law of contract, you've got the concept essentially at Article 9 that an aggrieved party is entitled to full compensation for loss sustained as a result of non-performance. Now, then there are other provisions about, I suppose, causative fault. So Article 15 reduces losses or damages if in part they're due to the aggrieved party's own acts or omissions or contributory conduct. Article 16 is provision for mitigation. A non-performing party is not liable for loss suffered to the extent that loss could have been reduced or avoided. We then see the damages in tort or obligation at part 3. And then when we get to the remedies, under the heading of other remedies, chapter 3, 37 deals with declarations, 38 is injunctions, 39 is specific performance, and then 40 is damages as additional or substitute remedy. 41, where the court has jurisdiction to entertain an application for an injunction or specific performance, it may award damages in addition to or in substitution for an injunction or specific performance. Now, just pausing there, this is not a case where there is an available injunction or specific damages, specific performance claim. Quite the contrary, the earlier injunction was refused. But then 42, the court may in its discretion on application of a claimant, where warranted in the circumstance, award damages to an aggrieved party in amount no greater than 3 times the actual damages, where it appears the court offensive conduct producing actual damages was deliberate and particularly egregious or offensive. So it's true that by its literal wording, it is without limitation. And I think it's true that a first instance court in the DIFC has not accepted the argument that the position of Article 40 is intended to take itself outside the realm of regulatory or contractual damages. So that is the authority that we referenced in our skeleton, I think at Al-Kharafi and Bank Saracen. But
do you want me to look at that? I have looked at it.
It's
let me just get it up, because I want to make sure that I've highlighted it.
Perhaps the best place to start is the let me just see if I can find it.
It's dealt with at 2898.
Thank you.
Just give me a minute. I think I will. That's the note I made. You referred to paragraphs 160 to 164, but there are no paragraphs 160 to 64, I think, is the note I made.
In the report, the numbering goes wrong, so one has to turn to page 2898 to find those paragraphs. 2898 of your bundle, it should be.
You obviously did a bit more digging than me, Mr. Montague Smith. This is Mr. Justice Cook, is it not?
I think it was Sir John Chadwick at first instance.
Right. So what do you say about that?
I think we say, first of all, that it's in our respectful submission wrong so far as it comes to the position under the law of contract, but the case is also distinguishable. I think if you go to paragraph 168, I'm trying to remind myself what page that would be on.
Well, it's following on here, so I think I can get there. Yes, 168. I do not accept those submissions.
Sorry, could you also give me the page reference? I'm sorry.
Yeah, sorry, it's 2899.
Thank you. So the point which we've made again in our skeleton is that having discussed the jurisdictional breadth of Article 42, in this case, essentially it was a contractual stroke regulatory issue that was being claimed. On the facts of this particular case, you can see that a submission was made that even if in theory it was available, then it wasn't warranted on the facts of this case following the trial. And at 168, the judge said he didn't accept those submissions. Properly understood, my judgment includes a finding that Saracen Alpin acted in deliberate breach of the financial services prohibition in treating and dealing with the claimants, and each of them as clients rather than as retail customers. It's that breach which gave rise to the losses sustained by the claimants. As retail customers, they should never have been exposed to the risk of investing in a structured and leveraged financial product. The submission the court made no finding conduct of Saracen was particularly egregious or offensive ignores my observation of the penultimate paragraph of my judgment at 21 August, where I said this: I'm satisfied the present is a clear case of mis-selling unsuitable investments to an unsophisticated investor and his equally unsophisticated wife and mother. That was carried out by employees of Saracen Alpin, motivated, at least in the case of Mr. Walia, by a personal interest in the fees that we generated by the exercise, without regard to protection the regulatory law was intended to afford retail customers. And then he went on to explain why he'd made an order for indemnity costs by reference to the findings summarized in the following paragraph. And then can you just look at the bit of text just above paragraph 61, just above 169?
Sorry, I'm just reading 18 as well there, where he's quoting from his own judgment. That conduct, as it seems to me, does take this case out of the norm. It is conduct which deliberately seeks to avoid the compliance which ought to be expected of financial institutions within the regulatory regime. So that's your point, that this is a regulatory, a breach in the context of or in the environment of a regulatory regime for the protection of investors.
Yes, and then the next bit of the text, he says, nor do I think that Saracen Alpin obtains assistance from the principles which would guide a court in England and Wales when deciding whether or not to award exemplary damages. Article 42 is not derived from the law of England and Wales, rather it reflects an intention to depart from that law in favour of the law in the United States of America. The lawmaking authority's jurisdiction has given the DIFC court power to award multiple damages in appropriate cases. This court shouldn't decline to exercise that power when circumstances require, on the ground the Court of Wales would not make such an order. Now, he then went on to impose that. But the reason I say this was both wrong but also distinguishable is that actually, when you look at the law in the United States of America, these damages are not available for breach of contract. And that's why we cite the Texas Supreme Court decision in Formosa Plastics, but there are many other examples of it, because normally exemplary damages are awarded in tort cases.
But why do you say he's wrong on the basis that the legislative authority in the DIFC has chosen to provide this unrestricted power without limiting it to the types of case in which in other jurisdictions similar awards are made, exemplary, aggravated, call it what you will. What the judge is saying, very experienced judge, is saying here in the DIFC, there is this unrestricted provision and power, and it should be used in appropriate cases, or at least it's open for a court to use it in appropriate cases. I know you say this is not an appropriate case, there's no basis whatsoever for it, is your case, but as the point of principle, why should I start from the basis or premise that this type of damages is restricted in other jurisdictions, whatever the restrictions may be, and you've just given one there that in the USA it's for tort damages. Why should I start from that premise in the virgin ground, as it was when this legislation was created, of the DIFC?
Well, I don't think time permits me to go through all of the arguments in great detail, but in a sense, it's an exercise of statutory interpretation, clearly. Statutory interpretation informed by the constitutional framework for the DIFC and Dubai and the UAE. This judgment in itself is a first instance judgment, which in my submission does not have full reasoning explaining why the answer is one or the other. And to the extent it's alluding to the United States of America as being the guiding case law, that case law seems to have been misunderstood or misinterpreted. But going back to the core question of statutory interpretation, there are two reasons principally why I submit these damages are not capable of being awarded in contract cases. One is the section is not within, and it's not inherently compatible with, the remedies for contract in the legislation. It's in a different part following the discussion about specific performance and injunctions. So the architects, the drafts of the legislation, in a sense, have created an impossible tension between damages being compensatory for breach of contract versus this punitive or aggravated form of damages if the court takes a dim view of somebody's behavior. And the reason that is, it's both unconstitutional because it ultimately does lead to a arbitrary deprivation of property interests if one is ordered to pay sums in excess of one's actual compensatory liability. But also, there's a strong public policy reason to read the legislation that way, which is actually reflected in the case law from England, Australia, the US. The public policy reason comes back to the concept of efficient breach, which is reflected in the highest appellate judgments of most jurisdictions. Now, that's not to say that you could not have an exceptional set of facts where simultaneously an alleged breach of contract is said to also give rise to a tort. And so it's conceptually possible in extreme facts that a contract breaker is simultaneously a tortfeasor and simultaneously liable for aggravated damages. But it's a very rare sort of case, and I don't in a sense need to trouble your lordship to produce the leading judgment on this topic, because on the facts of the case, even as pleaded, this is a bog standard commercial dispute. It's not a widows and orphans case of the sort the Bank Saracen one involved, with retail customers and a cynical regulated entity acting in breach of regulatory obligations.
Right.
So,
I think I have your arguments in full. Is there anything else you want to say on that?
Not really. I don't want to trouble you with taking you to the English, Australian, US authorities, but I would suggest that if you need to look at them, they're there.
You've referred to them in your skeleton, have you?
I don't think it's controversial what the position is in those jurisdictions. Just one final point, coming back to you about this notion of no party relying on their own breach. My learned junior has reminded me that there is a passage in my learned friend's skeleton, which was dated back in June, in which citation was made or reliance was placed on a Court of Appeal decision in the King Crude Carriers case, as well as Mackay and Dick.
Which paragraph is this?
I think it's paragraph 111. Does your
I'm just reading it. I've highlighted it. D cannot rely on C discovering and calling out, etc.
Yeah. Now, I mean, I've already tried to address that on the facts of this case, that it's not actually, we didn't terminate in reliance on our own misconduct, but in reliance on the repudiated conduct of Mr. Fonmante. But the point I wanted to draw to your attention, and my learned friend perhaps will do so, or will have to do it in reply, is that those cases, Mackay and Dick and King Crude, have been the subject of a recent United Kingdom Supreme Court judgment, published, I think, in the past 2 weeks.
Is that in the bundle?
I don't think it is in the bundle, and I think the Supreme Court overruled the Court of Appeal decision and essentially held that the Mackay principle is wrong in law. And that's partly because the innocent party's claim for breach of contract lies in damages, not in debt. So there's a bit more law to be addressed on that particular topic if it's perceived by learned a friend, but I may have to come back and reply to see how he addresses the Supreme Court decision on those two authorities.
Right. Well, you'd better get the Supreme Court authority decision added to a supplementary bundle. Please don't mess up the pagination of the main bundle. Wherever you put it at the end in the bundle.
Okay. Or
just circulate it.
Yeah.
Circulate it as a single document.
So I don't have it at my fingertips, and maybe both of us will have to assist you further with submissions on it once you've read it. But I just want to flag that up now. To try and then move very quickly, if I have any available time still. Can I now turn then to our abuse of process arguments? Your Lordship has already identified the relevant cases in a sense. I don't want to trouble you on the law, and I appreciate that there's a degree of discretion and evaluation on the part of the court. What I did want to, though, make quite clear is that these allegations were put in issue in the proceedings before Mr. Justice French, and they were relied upon. Now, of course, he didn't make findings on them, and his position was actually consistent with our position that they were irrelevant to the application to injunct the rebranding. But it is worth looking at the details of claim that were submitted at the time.
This are you referring to? I wasn't entirely clear about this. So there was an intended Part 7 claim, brief details of claim. Am I right in concluding this? I didn't track it down, apart from its quotation, it being quoted. I think it's quoted in Mr. Teixeira's evidence, if I remember correctly. I've read a lot of evidence the last few days. So there was the Part 8 claim form, but then there was this additional indication of a claim that was to be brought, would be brought, in relation to what is now the main subject matter of this claim before me. Is that right? That summary?
You've got the gist of it, but can I turn you to just the document so I don't end up confusing things further? If you look at page 173, using red numbers,
yes.
So I think 173, you would find the Part 8 claim form that was issued back in 2023.
Yes.
And the Part 8 claim form identified the perception that there was some imminent risk of harm and sought the remedy of an interim injunction restraining rebranding with various detailed subparagraphs, as well as seeking costs. Now, one can have a degree of intellectual gymnastics as to whether that application was an abuse of process, in the sense it was brought as a freestanding application for an injunction without, in turn, containing a claim for final relief or remedies. And it was because of that, and part of the price of securing an adjournment so that we ended up with an inter partes hearing of this application, that the claimant indicated to the court that it was ready, willing, and able to bring its substantive claim. And to illustrate the substantive claim that it was ready, willing, and able to bring, it identified and provided the court brief details of that claim, which are the ones you find at pages 179 to 180 of the bundle. And so, in a sense, this was the draft 7 claim that the claimant was indicating it was about to bring to justify the application for an interim injunction. And so those brief details of the claim at page 179 start off dealing with the rebranding point, and at paragraph 4 identifies the claim for permanent injunctive relief that would be sought in that claim. Paragraph 4, your lordship has that at 179.
It's 5 and 6, which
But then
is highlighted.
5 and 6, in the same intimated claim, the claimant indicated that it was going to claim for the gross revenue shortfall, including, you'll see, at 5C, the position to date, but then at 5D, the forward-looking position from 1 September 2022 to 20th of June 2032. And so it then says, in breach of the agreement, the defendant has asserted its gross revenues were less than actual gross revenues, has failed to pay the claimant sums due, has failed to prepare annual audited accounts. And then over the page at 180, paragraph 8, the allegation the claimant had already suffered loss and damage, and if things had been done properly, it estimated its loss to be $6 million. And then there was this reference to Article 42 at paragraph 10, not actually quantifying the sum, but just simply seeking 3 times whatever sum or the sum thought appropriate by the court. And you'll see the remedies sought summarized there. Now, as it happened, because of the urgency with which this all happened, and because of the dispute resolution mediation provision, the claimant didn't actually issue that Part 7 claim by the time we came before the judge at the Part 8 injunction application. And there was a bit of a debate with the judge as to whether the judge should treat the application for an interim injunction as a claim for a final injunction to the trial standard, effectively, although there'd been no directions for an expedited trial. And by then we hadn't even, for example, received a statement of claim or defense, and there hadn't been disclosure and so forth. So in the end, although Mr. Montague-Smith encouraged the judge to treat it as a final trial, we didn't, and the judge didn't. So the judge publishes judgment, although it's a bit like a strikeout judgment, because he formed the view that there wasn't even a serious issue to be tried. It was a hopeless case. The judge then asked for submissions on costs, and my own friend's submission on costs was costs should be reserved until the conclusion of the substantive litigation. The judge said, well, that doesn't make any sense. This was a self-standing Part 8 application. I'm going to order costs to follow the event. And then we ended up in the quantification and the enforcement process for costs. Now, in that sense, the Part 8 claim was disposed of, but actually it wasn't dismissed. It's still, in a sense, a live piece of litigation on the court file, because there's been no order disposing of it with finality. What the claimant then does is, rather than starting the Part 7 claim within the existing claim number, it issues completely separate, fresh proceedings, a Part 7 claim. And in the Part 7 claim, its complaints include subject matter that was raised for the court's consideration in the Part 8 claim. So, in a sense,
were they raised in the Part 8 claim practically and effectively? They were simply notified in the Part 8 claim as an intended Part 7 claim that would be brought, but in the meantime, they were seeking the Part 8 injunction, relief by way of injunction only. Let me put it to you this way. If the claimant, instead of starting a new Part 7 claim, these proceedings, which are before me at the moment, if the claimant, even with the delay that has occurred, went away, tried to get third-party funding, took time getting it, got it, and came back to court, would it be an abusive process if he had applied to bring under the same claim number the Part 7 claim that he intimated and now brings with much more particularity, of course? Would it have been an abusive process if he had, instead of doing what he's done, continued with the same case number and said, right, now I want to bring this Part 7 claim that I gave notice of back last year, and we want directions as to pleading it out and so forth. Would that be an abuse?
There's quite a lot to unpack there, but I'll do my best to do it.
I mean, there is a lot to unpack because it's troubling me. What's the difference, in effect, is the real thrust of the question. What's the difference? Okay, if that wouldn't have been an abuse, why is this an abuse? These proceedings.
Okay. The first point to bear in mind is that there was an interim undertaking given my client not to rebrand for a period of months until Mr. Justice French dealt with the injunction application.
Yes.
So there is still a live cross undertaking in damages from the claimant in those proceedings, which they are at risk of having to deal with by way of an inquiry as to damages in those proceedings. On top of that, there was a cost order made, which they didn't comply with until we had to take enforcement steps. But that's against the background of Mr. Montague Smith, for example, on behalf of his client. If you look at page 1000 of the bundle, if you look at page 1000, this was the end of my learned friend's skeleton for the hearing in front of Mr. Justice French, in which there had been quite a lot of rehearsal of the alleged dishonesty, obviously for prejudicial jury benefit, but the judge wasn't drawn down that path. But at paragraph 84 on page 1000, you will see that an applicant would normally be obliged to undertake to bring substantive proceedings immediately. This clause 19, required mediation first. Since the original filing of this application, claimant has been able to fulfill the steps required, and D, refused to participate in any mediation. Now, we don't accept that as an accurate statement, but anyway, the claimant, therefore, now is able to undertake to commence proceedings as soon as reasonably practicable, substantially in terms of the draft claim form. So that was in September.
The draft claim form being the particulars we've just been looking at.
What we just looked at, exactly. So there was, and I'm not going to complain right now or allege that there was a specific.
I'm sorry. Is it being said that my client has breached an undertaking to the courts?
I'm not saying.
That's what's being implied by the submission.
Don't talk across each other.
Sorry. I'm not suggesting for present purposes there's been a breach of an undertaking, but the point that I'm trying to make is that Mr. Justice French was seized of the proceedings. And the concept was they were applying for urgent injunctive relief in aid of a substantive claim, which would follow shortly thereafter. Having been rejected,
as soon as reasonably practicable.
So then, having been rejected in no uncertain terms by a fairly comprehensive judgment that their case was hopeless, with a cost order. There's no order that dismisses those proceedings with finality. There is an order dismissing the interim injunction application, and there is an order for costs. But technically, there's still a live piece of litigation on the court file. Now, we then have to enforce the costs. We're sitting there thinking, shall we pursue the cross undertaking in damages relating to the undertaking that we gave that delayed our rebranding exercise? And then we terminate the agreement. Now, rather than starting those proceedings against the background of the existing proceedings, for some inexplicable reason, 9 months pass, then there's a pre-action letter from a new law firm. We have to clarify who's actually representing whom, because the last time we heard from them was a different law firm representing the claimant. And then a completely fresh claim is started. And it's important to note that the new law firm and the fresh claim do, in fact, seek to advance a collateral attack on the reasoning and conclusions of Mr. Justice French by suggesting he got the interpretation of the contract wrong. But in the absence of any appeal or any substantive claim before that judge. So you could infer from that not only are we being vexed twice, but there's an element of forum shopping going on or trying to start with a clean slate, without fully addressing the outstanding procedural issues from the first set of proceedings. So, if I may say so, we are in the territory not of there being a final and binding res judicata that precludes the bringing of a second claim. We are squarely in the territory, though, of Henderson and Henderson. Should and could these proceedings or these claims have been brought in the existing proceedings, rather than separating out and starting a fresh proceedings, particularly if in the
I'm sorry, how is your client being harassed, vexed, by reason of the specific fact that separate proceedings have been brought, as opposed to going back to issue within the existing case number, the Part 7 proceedings that were intimated in the detail that we've looked at? Where is the additional prejudice? So I go back to my question. Would it have been an abusive process for the claimants to have said, look, we gave this undertaking to commence proceedings as soon as reasonably practicable. We didn't have the money to commence them. We've been looking for a third-party funder. It's taken us the best part of however many months it was. Here we are now. We're ready to start our Part 7 proceedings. It is now reasonably practicable for us to do so. The only difference, it seems to me, is that they've issued a separate plaint, as we would say in England, or whatever.
Well, yes, well, I mean, there is a lot of prejudice because, first of all, we're having to deal with a second set of proceedings at further cost, delay, disruption to management time, and also all those aspects of things. But also, the claimant has cherry-picked material from the first set of proceedings. So, for example, there's a repeated but inaccurate reference to the witness statement of Mr. Texera in the first set of proceedings, where Mr. Texera has a passage where he says, look, we think we paid the right amount, but this is all subject to further reconciliation. And so it's possible upon further reconciliation that the numbers might be different, but we don't think they'll be material, even if they are. And that has now been constantly and wrongly repeated in this set of proceedings. They've taken a witness statement from one set of proceedings to introduce them to another set of proceedings to suggest that somehow there's either a quasi-admission or some inconsistency in the evidence.
And you're not answering my question. I'm sorry, you're not answering my question. Why? What is the additional prejudice by starting fresh proceedings if they could have gone back and put all of this in the existing case number and simply started the Part 7 proceedings that they now bring in those earlier proceedings?
I can try and sort of repeat the point I've made. I apologize if it's not a complete answer, but we're being vexed twice, having won the first time round.
Wouldn't you be vexed twice just the same I'll leave it at this. Wouldn't you be vexed twice just the same if they'd gone back and said to the court, or applied to the court, or filed, here is our Part 7 claim in this action, which we intimated back in whenever this first saw the light of day? I've forgotten the precise date.
Possibly, but I mean, buried in all of this, I think your lordship picked up on this yourself at the beginning of the hearing. They are challenging the correctness of Mr. Justice French's judgment.
Well, that's a different matter, and I'll say it immediately. Mr. Montague Smith is going to have very great difficulty in persuading me that I should not strike out paragraph 29.3 and paragraph 29.5 of this.
Well, I hope you'll keep an open mind on that, because obviously it sounds like you've made up your mind on it.
I haven't made up my mind. I've got a provisional view on it, Mr. Montague Smith.
All right.
That might be the most clear example of abusive conduct, but it does, in my respectful submission, illustrate why, if you have one judge who's seized over the case and you want to come back and complain that he's got this bit of the case wrong and he needs to revisit for the purpose of the balance of the case, it should be the same judge or an appellate court that you go to. What you should not be doing is pretending that didn't happen, arguing that it was wrong, but then starting a completely separate set of proceedings some 9 months to a year later. Now, you may be right. If we did an economic analysis, we may end up having to spend precisely the same amount in both sets of proceedings. But in a way, it illustrates that the first set of proceedings should not have been brought in the chaotic, urgent manner in which they were, because they were struck out when it came to the injunction application on the basis it was a hopeless application. So you could say that was the abuse rather than the second set of proceedings. But somewhere in the analysis, we've had to incur twice the costs fighting two pieces of litigation, which could and should have been one.
Very well. I have your point on it.
And then just the final point is on confidentiality. I don't need to spend much time on this, but we submit that Mr. Font's own evidence it implicitly admits a breach of confidence, as is the disclosure that they've gone off to a litigation funder to bring this claim. Now that the court clearly has a discretion as to what is the right remedy or consequence in terms of a breach or misuse of confidential information, but we've never had any of it returned to us. And one would either restrain its use, if one could, or if it's already been used, strike out the case as an abuse. Those are really my submissions in a nutshell on that, but you'll have seen that we deal with it in the skeleton.
Yes, I've read all of that and looked at the authorities, and we'll consider those in due course. So is that you finished on your submissions?
Let me just please double check on the WhatsApp thread if I've missed anything critical. I think the good news is that I have nothing further to add, I don't think.
Very well. Well, thank you very much for that. And we've come to the end of the working day, which is extended in Dubai. There's no avoiding that, I'm afraid, having regard to the time lags that we operate under at this time of the year. So to our colleagues in Dubai, thank you for the extra time that you've put in the working day. Mr. Montague Smith, I will hear you first thing in the morning. Is there anything you wish to say at this stage before we adjourn?
Can I just clarify this last, where we ended up on this last section, because it's very surprising to me that my learned friend puts his position in the way that he does as to what happened last time. And I'll just give you a headline, because I wouldn't want you to go away thinking that we'd offered an undertaking and given an undertaking which we hadn't complied with. That is not true. So the first point is, if you look at his skeleton argument, what he says is that my client issued a claim for the same relief, that is for the fees claim. So paragraph 16.2, for example, deliberately chose to issue a freestanding and substantive claim against SIR, and then says its brief details of claim included claims for damages for the alleged underreporting. That is simply false, and it is very surprising to us that my learned friend would put that in his skeleton argument, because he must know that that is not what happened. The way that interim injunctions work in this court is that if they are brought pre-action, they have to be brought by Part 8 claim form. That is baked into the rules. That's what the rules say. And that is different from England. You would do it by application notice. So if you were pre-action, what you would do is you would issue an application notice, and you give an undertaking, or you offer an undertaking, to issue the substantive proceedings. So in this case, the relevant substantive proceedings would be for a final injunction in the terms sought in relation to the interim injunction. But given that there was certain facts were known about the fees dispute, it was anticipated that that would be included in that substantive claim. So the idea that it's abusive to issue a claim form in Part 8 form, included for an interim injunction, is nonsense, because that's what the rules require. And so then the next question is, where should the claim for the substantive claim go? It cannot go in the Part 8 claim form, because Part 8 claims are for claims which don't have any factual dispute about them. So you have to issue another claim form. And then there's this position, well, they gave an undertaking. We did not give an undertaking to issue. What happens on injunctions is that you offer undertakings, which if the court makes the order, the court will accept. And therefore the question is whether or not an injunction was offered which was accepted. Now, none of this is put forward as the basis of the application. And so but I would not want Your Honour to walk away from the hearing today to think that either there's been an abuse in the way that the first claim was issued, that the claim that is in these proceedings was somehow issued in those at that time, or that there was an undertaking that was given that was not complied with. Now, all of those things are things that you have been told by my learned friend, and none of them are true. So that's all I wanted to clear up at this stage.
I'll let you develop that and demonstrate it tomorrow. But I do have one question just to finish this off. If there is a Part 8 claim in existence, the court, correct me if I'm wrong, does the court, I'll ask the question, does the court have power to deal with an application or receive an application that the existing Part 8 claim should not continue as a Part 8 claim, but henceforth shall continue as a Part 7 claim?
Yes, of course. Yes.
So just I wanted to be sure that the question I was asking a few moments ago about what is the difference as between starting a fresh Part 7 claim and, I'll now use the term, converting the existing Part 8 claim that was brought for the injunction originally. Am I right in thinking that it would have been possible for the claimants to go back to court and say, there is this extant Part 8 claim, we indicated that there was going to be a claim for the revenue claim, I'll call it. We would like an order converting the existing Part 8 claim to a Part 7 claim and directions for the filing of the particulars of claim.
In principle, it would have been possible, but it would have had to come before Justice French's decision, obviously, because once he's decided that claim, the Part 8 claim is for interim relief, then he's decided the claim, and that's the end of that claim. So you can't amend into an existing claim form. But in principle, before that moment, it would have been possible to make that application. It would be highly unusual. There's no practice in the DIFC court that is done. And
no,
normally,
why I asked is I've done it a number of times. I've converted Part 8 claims to Part 7 claims because it didn't seem to me right.
That does happen. That does happen. But what doesn't happen is on a regular basis, at least, I've never seen it, is somebody issuing an interim injunction pre-action with a future claim to come, but then amending into the Part 8 claim form the particulars of the new future claim and then asking for it to be converted to Part 7. And that's not a practice that the court would encourage, because you're only supposed to put into part claim forms things that you genuinely believe can be decided without about facts. Exactly. But of course, it does happen that people characterize something as a Part 8 claim and then a factual issue arises and the court has to deal with it. And the rules are very flexible about that. The question, though, is, for your purposes, is it abusive not to have done it in that way? Very well. And I'll deal with that tomorrow.
It is indeed. And thank you very much for that. I don't think anybody is going away on either this side of the bench and at the bar with any misunderstanding about what is being argued. Thank you for that clarification of your position, which I will weigh carefully and fully in due course. So we'll adjourn there for the day and resume tomorrow morning, 8 o'clock English time and midday in Dubai. Thank you, gentlemen. Good day to you all.
Thank you.